already addressed that. Yep. Oh, sorry, no, I haven't. Okay. All right, we have we'll go back on the record. Wait, do we have the court reporter? Oh, there she is. We'll go back on the record. The defendants are present with counsel, as is counsel for the state. I need everyone to please be quiet as they enter the courtroom, and a reminder, everyone is to turn off their devices. There shall be no use of electronic devices or you're going to be asked to leave the courtroom. So come on in, have a seat so we can get started, and everyone please, I would appreciate some quiet. Are the jurors in their jury rooms? They are. So I would ask Mr. DeCosta not to speak into the microphone. We'll continue and address the Richardson hearing request that was made prior to the lunch break. And I'll hear as succinctly as you can any additional argument that you may have been able to, now with a 1 hour lunch break, more thoughtfully thought through.
No, some more, Your Honor.
Okay.
Florida is a discovery state. Scipio stands for this exact situation. That I trust that Your Honor saw the case law. The
Yes.
State Commission was very similar. It was considered to be harmful. The situation here is different. Now, I objected and I went sidebar because I thought he was going to try to comment on the video based on the knowledge of him in the video. But that's not what this was. He sat down in their office and he did what they have Latham do it. He did photogrammetry. He sat down and looked at one photo and another, not based on any personal knowledge from when he was there, and made an assessment on height. Now, there's a whole host of things that I would have done. The stuff that I said before, I would have done that. I'd also get an accurate reading on his height. I don't think he's 6'4", that's my lay opinion, but I'd want to know exactly what is his height. He's also giving an opinion based on a person that is running. We touched on this in the Dauber hearings that when a person runs, they draw. Interestingly, their expert Latham said he would never touch that video because it wasn't reliable for him to do an expert analysis.
Okay, but let's focus it. I care nothing about Mr. Latham and programmetry at this point. It's this witness and the discovery violation that you're alleging involving this witness's changed testimony?
Correct.
Okay.
So, Your Honor, I've brought out, yes, redacted testimony, or recanted. So I've laid out what the prejudice is to us. I mean, the fact that I'm having to do on the fly a cross-examination of a case that's 5 years old on something that I could prepare for, that I've been preparing for years. So there's that. That's the prejudice. Was it willful? Absolutely. They knew that this was coming in when they created that slide. Again, we don't have a problem with the slide. We have a problem with what came out of the officer's mouth. Based on Scipio, the second that they knew that he was going to say, I was wrong previously, they were under a duty to give it to us. Now, the reason why we stopped, and this wasn't asked about anymore in deposition, because in deposition he was asked the question, Your Honor has a full transcript, do you know the height or weight of the shooter? And his answer was, I don't know, I don't know. The remedy that we are looking for is to strike that portion of his testimony with an instruction to the jury.
Which portion specifically?
When he said, based on my view of that exhibit, I was wrong, and then gave his new opinion of the person was around my height.
Okay, and I'll hear from the state.
Judge, I would just say that I don't believe it's a material change in his testimony. He does not give a height. He was personally there that day, looked at the video. This is evidence that the defense has. His testimony today is, and as it has been when it was brought up by the defense, he gave estimates, he gave ranges. And today he just said, looking at that, knowing how tall I am, that's me in that video. I think I was wrong. I think he's a little closer to my height. He didn't say he's 6'3". He didn't say 6'4", 6'1", any of those things. He just said, I think he's closer to my height. I don't think it's a material change in his testimony.
Okay, thank you.
It's a change of nearly a foot from his previous testimony. It's a material change in his testimony. I understand and the important thing, Your Honor, this is our entire defense. we have been very clear what our defense is on this case, that it is all based on a misidentification. The height and the weight is the biggest thing. We're under an obligation to give that. They didn't. It's a violation.
Okay, thank you. I am guided, of course, by our rules of procedure that deal with discovery, Rule 3.220, B1B specifically, but also case law as expounded upon by our appellate courts that set a precedent. And the Florida Supreme Court has stated that unlike a failure to name a witness, changed testimony does not rise to the level of a discovery violation and will not support a motion for a Richardson hearing. And I'll cite to you the case of State versus Evans, 770 Southern 2nd, and that's at 1178. But if this were a Richardson violation, I would further make the finding that I don't find it to be willful, I don't find it to be substantial, and I don't find it to have a prejudicial effect on preparation. A witness who comes in to make a different statement than he or she has made previously is subject to impeachment, which you successfully did with the use of your deposition, as with any witness. But more critically, this isn't focusing on the substantive nature so much of the violation, but the procedural nature of the violation. This is a discovery procedural rule. And under our rules of procedure 3.220 B1B, the Florida Supreme Court has also advised, and the specific language in the rule does not require the disclosure of an oral statement when such a statement has not been reduced to writing or recorded in any manner prescribed by the rule. And this witness's oral statements to the state attorney in preparation for trial, as all witnesses meet with attorneys every time they prepare for trial, there is nothing at all improper about that. And in fact, I will be advising the jury that there's nothing improper about that, is not subject to disclosure since it was not recorded, as I understand, not recorded or transcribed in any way. Is that correct?
Yes, Judge.
Okay. It was a pretrial prep meeting a week ago where he looked at this exhibit and estimated, well, of course, he knows his own height and told us what his height was and gave his explanation or estimation as to height. So I'm not going to find a Richardson violation. I'm not going to strike the testimony. But I think the record is made on behalf of the defense, and that's my ruling. So other than that, are we ready to bring the jury in and move on?
One thing I wanted to bring to the court's attention, I've let one of the counsels know, I didn't let Ms. Schleich know, she wasn't in here. I guess, well, two things. One is, in the break, the state of Florida became aware of some of the jurors' faces on live stream.
The court has become aware of that as well. We have talked to the cameraman. He is aware that the jurors' faces shall not be filmed. The streaming, we do have a 2-minute delay, so we were able to take it down off YouTube, take it down off Law and Crime Network, take it down off other news video clips, but I want to once again reiterate that the jurors' faces should absolutely not be filmed. Okay? Let me get a thumbs up from the cameraman. Thank you so much.
I'm not sure which jurors it was.
It was these two right here. Yes.
Okay, I just want to make sure the court was aware. Another thing is I had a very incredibly brief interaction with the juror when I was walking into the courtroom. He wanted to know how to get into the courtroom. I told him I didn't know, I would check. And
How to get into this courtroom?
he was waiting in the hallway by himself, and so he didn't know how. So
Okay.
I just walked by, and I answered him. I said, I don't know, I'll check. And I think the bailiffs went out.
So he was trying to get into this door?
Trying to get into the juror room, correct.
So this-
Or the exit.
Okay, I see.
He was in the hallway out in front of the courtroom.
Understood.
Back into the jury room.
Okay.
Honor, just a request moving forward. I don't know if it was part of your instruction. It may not have been, but I know I've had it routinely, that they tell the jurors that in the event that you see one of the attorneys and they, walk away from you and don't speak to you, know that it's because I've instructed them not to. And I think that that's what the state should have done. Just, any interaction, even with a smile, a facial gesture, is an improper communication with the juror. It should have been head down, walk away.
Okay, I have instructed them, and I will instruct them again, if that would.
I'm not saying the jury, I'm asking the other attorneys that in the event that any juror tries to speak to them, that they, as an officer of the court, walk away with.
Okay, I will ask all attorneys to not speak to the jurors and to walk away from the jurors. I will advise them again that that's what y'all are going to do because you've been instructed to do so by the court. But I've also instructed them on multiple occasions that they're not to approach you. And, you know, it's human nature. It's holding the door open for Ms. Schlacks. I think one of them did on Monday. But I will once again remind them so that we don't have any issues with juror contact going forward.
I don't want to make it seem like the state got in trouble for that interaction.
No, understood.
Yeah, if the court has done it before, you know, I certainly.
I will remind them again along with my other reminders and admonitions, so it'll be part of my usual warnings to the jury.
Very good.
Your Honor, final request is an or tennis motion to compel. Officer Collins has made his own height material in this case, but that's all based on his own assessment. I mean, I had my opinion when he walked by of height. I don't believe that it's 6'4". I have him under subpoena. This is not something that I've done before, but I do want to have an accurate measurement of his height if he's saying that the person that he chased was around his height.
Okay, is this something we have to deal with right now? He's not the next witness, right?
No, this is on Collins.
Okay,
Who already testified, just putting it, I want to make sure that it's contemporaneous with
okay.
everything else with Collins.
And what is it you want me to compel? Why don't, since it's not an issue at the moment, you can put it in a pleading in writing. I'll have the state respond, and then whatever it is you're wanting me to compel, I will address that and think about it and rule on it. But if it's not for any witness today, then I would ask let's hold off on that until it becomes an issue. Okay. Are we ready to bring the jury out?
Yes, Your Honor. Oh, wait, I'm sorry. Mr. Atkinson gets to speak. Go ahead.
Just to expedite the next couple of witnesses, I've shown defense counsel a series of photographs that we intend on introducing. I was going to introduce them now.
And that they're being stipulated to? All right, let me also say this, because one thing that happened in the last time when you stipulated to the series of pictures is then that both of my clerks here have to label them and sticker them and do this and do that. And that is also, no offense to you ladies, a little distracting. So this is all something that should be done either before court, at the beginning of the day, or at the end of the day, or during lunch recess, although they need their lunch breaks too, not during the testimony. I'm trying to reduce, eliminate, minimize as much disruption during testimony as I can, from doors opening and closing, people's phones ringing, talking and whispering. We need to not have that done in the middle of testimony. Okay, but that said, if there are items to be stipulated into, then tell me now what those are, and then I'll inquire of the defense.
They start you on the state's list goes through 5C, and we state 73 through 107. Series of photographs around the ensemble.
So 73 through 97 are being stipulated to?
73 through 107.
Through 107, okay. Is that with the approval of Defendant Whitaker?
Yes, Your Honor.
And, thank you, and Defendant Robinson?
You want to answer?
Photos number 73 through 107.
No objection.
Okay, those will be marked into evidence by stipulation.
The next set, Judge, is states 5D through 6Q, which would come in as 108 through 147. It's a series of photographs from the town boulevard address.
Okay, and some of those exhibits have already actually been moved into evidence.
Some were used from Ms. Buckley earlier, but these are the remainder of the photographs.
Okay, then the remainder between 108 and, what number did you say? 176? 147. 147. 108 to 147. Any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No objection.
Okay, then those will be marked into evidence by stipulation.
The next set is for 7U through 7Y, which would come in from 177 to 181. It's a series of photographs from 7201 Arlington Expressway.
All right, those are 5 photographs. Any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson? Okay, those will be marked into evidence by stipulation.
Finally, Judge, states 10N, which would come in, I believe, is 200
10N?
Yes, ma'am. I think it was written in after.
Oh, I don't have that one. Okay.
248.
Wait, what number? My exhibit only goes up, my exhibit list only goes to 226. Oh, all right, well, okay. I'll want an updated exhibit list if possible, but any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
And this is 244 to 247? No, what numbers are these?
Just number 247.
Oh, just number 247, the map? Okay, got it. 247 will be moved into evidence by stipulation.
On one of the lists, it was 248, on the other, it's 247. For the record, the only thing we're introducing now is the map, not the cash report.
All right, anything else we need to take up before we bring the jury out?
No, ma'am, not from the state.
No, Your Honor.
All right, very good. Then let's bring them out, please.
Judge, for the two crime scene detectives, can I inquire from here, from the evidence cart?
Yes, as long as you speak loudly and clearly into the microphone.
Yes, ma'am.
All right, thank you, ladies and gentlemen. You may take your seats. Okay. Well, while we wait for Mr. Whitaker's jury to come, I do want to inquire if during this lunch recess, any of you heard, watched, or listened to any newspaper, television, or radio stories that may have been printed or aired about this case? No? Okay, I see no hands raised. And has anyone attempted to speak to you or approach you in any way to provide you any information or any reason about this case? And I see no hands raised. All right, let me also remind you, ladies and gentlemen, that during the course of this entire trial this week and next week, of course, you're not to talk among yourselves. You're also not to speak to any witnesses who might be waiting outside the courtroom. You're not to speak to the attorneys about any subject matter whatsoever until your deliberations are complete. In fact, I have told the attorneys that they are not to engage with you at all. And so if they see you coming, they are going to turn around and go in the opposite direction. They're not going to talk to you. And that might seem rude and disrespectful, but I assure you that they are not being so. They are following this court's orders and their rules of professional conduct to have no contact with you until your deliberations are complete. So please, again, do not engage them in any conversation whatsoever, even on a topic as mundane as the weather. All right? I thank you for that. We will await Mr. Whitaker's jury. Who was asking? Okay.
Jury 9 in the courtroom.
All right, thank you, ladies and gentlemen. You may take your seats. And before we begin, let me just inquire of you all if during this 1-hour lunch recess, any of you read, watched, saw, listened to any news stories about this case. If so, please raise your hand. Okay, I see no hands raised. And did anyone approach you to speak to you or have anything to do with anything having to do about this case? If so, please raise your hand. Okay, and I see no hands raised. Thank you. Lastly, I do just want to remind the jurors that as you come and go and during lunch recesses or end of the day recesses or any recesses where you exit the courtroom or the jury room, you're not to speak to any witnesses who might be waiting outside the courtroom doors. You're not to speak or engage with the attorneys should you see them in the hallways and the elevators or in the lunch spots. They are not going to be able to speak to you about anything at all. In fact, if they see you coming, they're going to turn and go in the opposite direction, or if you get on an elevator that they're on, they're going to get off of it. And that might seem rude or disrespectful, but I assure you they are simply following this court's orders and their rules of professional conduct that they are to have no contact with you whatsoever until this case is completed. So please do not engage them in any conversation whatsoever, all right? So with that, I will call upon the state to call its next witness.
Yes, ma'am. The state would call Detective Dunn.
Detective Dunn, please. And Mr. Atkinson, and for all the lawyers, a request has been made by the jurors for you all to speak closely, clearly, and loudly into the microphones. All right, Detective, if you'll come forward and be sworn. Yes, if you'll have a seat in that chair, please speak closely, clearly, and loudly into that microphone.
Good
You
afternoon.
may proceed.
Thank you, Judge. Good afternoon, ma'am. Will you please introduce yourself to the jury?
Yes, my name is Noelle Dunn, and I'm a retired crime scene detective with the Jacksonville Sheriff's Office.
Okay. How long were you a crime scene detective with the Jacksonville Sheriff's Office?
I was a crime scene detective for a little over 19 years, and I was with JSO for almost 26 years.
At the time that you retired and back in 2020, were you what is called major case certified?
Yes, I was.
Can you explain to the jury what that means?
Basically, it means that I've undergone additional training where I'm able to handle homicides and also other advanced types of crime scenes, such as officer-involved crime scenes, successfully. And it also means that I've gone through additional training. For example, I've had multiple classes in advanced crime scene investigation techniques, including a certificate of proficiency from the Institute of Police Technology and Management, which involved over 180 hours of crime scene processing techniques.
Ma'am, I want to draw your attention to January the 15th of 2020. On that day, were you dispatched to 7001 Merrill Road?
Yes, I was.
Is that in Duval County?
Yes, it is.
When you arrived on scene, your role in this case, you've said, is as a crime scene detective.
Yes, that's correct.
And when you arrived, was the scene secured?
Yes, it was.
Can you explain to the jury what that means and why that's important?
Basically, when they talk about scene security, it just basically means that the officers that have responded initially have used crime scene tape to rope off the scene where people cannot just walk into your scene.
And can you explain to the jury what your role is as a crime scene detective when you arrive on a scene like this?
So basically, when I arrive on a scene, I meet with either the officers or the detectives if they're already there, and I get a synopsis of what's going on, and so I am able to better understand how to go ahead and proceed and start processing the crime scene.
What does it mean to process a crime scene? What are your responsibilities there?
So generally, it's any kind of documentation and evidence collection at the crime scene, and that can include photography, evidence collection, and any kind of measurements that are necessary.
When you are taking photographs of a scene, do you often take photographs to try to give perspective of where items are?
Yes, I do. I take overall photographs of the entire scene, and then I also take close-up photographs of the evidence.
Okay. And the jury's going to see in a little bit, but in some of the photographs, we can see what are called evidence placards, right?
Yes, that's correct.
Okay. Importantly, they're numbered. Are you giving any kind of order of sequence or chronological order to the evidence that you're finding, or is that the order that you found things as you're processing the scene?
So generally, the crime scene placards, even though they display a number, they don't refer to a chronological order, either the chronological order that it occurred during the crime. It actually refers to the order that I do see it when I come across it during my investigation.
Your Honor, permission to publish a series of photographs that have already been introduced into evidence.
Yes.
Ma'am, can you see on your screen where it says 7001 Merrill Road?
Yes, I do.
I'm showing you states 1. Can you explain to the jury what's going on in this photograph?
Yes, that's a view from Merrill Road looking north to the shopping center, and that's basically the entrance to the shopping center off of Merrill Road.
States 2.
So that's another view. That's inside the shopping center area in the parking lot, and that's a view of the businesses. That's looking at like the south wall of the businesses.
States 3.
That's a view of the Express Employment Professionals business. That's the east wall of the business, looking at it from the parking lot.
Okay. So just as a reference from states 2, you're kind of over here for stage 3. Is that fair?
Yes.
And then in stage 3, it's looking back towards where you were in stage 2.
Yes, that's correct.
States 4, just further down that wall.
Yes, it is.
And we can see the victim there on the ground.
Yes.
Going further down that same wall, states 5
Yes, it is.
and stage 6.
That's another view of the shopping center going across.
State 7, what do we see here?
So that's a slightly closer view of the Express Employment Professionals business, and you can see the damage to the south glass window.
States 8,
That's also a closer view of the glass on the south wall.
states 9,
That's a view from the inside of the business looking back out. It's that same glass wall.
and states 10.
That's the east side of the window that's on the wall there in the same business, the Express Employment Professionals.
And I know you can see it in the photograph, but you can see that the blinds are down in some of these photographs, states 9. Did you have any difficulty seeing out the blinds?
No.
States 11,
That's a view of the east window, sort of looking back to the south window.
states 12,
That's a view out in the parking lot showing evidence number 9 and the victim's vehicle.
and when you take overall photographs, do you progressively take closer and closer photographs of the evidence at a placard?
Yes, I do.
So in states 13, we can see placard number 9,
Yes.
and what is that?
That was a casing that was recovered from the parking lot to the south of the victim's vehicle, and it was an unknown caliber casing.
States 14,
That's a close-up photograph of that same casing. It's showing the head stamp of the casing.
and that's here.
Yes.
States 15,
So that's an overview of the east side of the shopping plaza. It's showing some of the evidence placards that were labeling individual pieces of evidence, and also you can see the greater scene, including the victim.
states 16,
That's another view, the same view of the shopping center from a slightly different angle, again showing the evidence placards and also showing the victim and some of the other evidence.
states 17,
That's a view looking towards the south. It's the same general area showing the evidence placards and also the victim.
states 18,
That's a closer view, also looking to the south. It's showing the victim on the sidewalk in front of the shopping plaza, and also the location of placarded items of evidence.
okay. And in this photograph, we can see, I'm circling it, but for the record, it's kind of a white box with orange on it, and then some other material here. Can you explain to the jury what that is?
Yes, there was a medical business that was close by, the Baptist Health. And when this incident happened, the people used their medical supplies to attempt to treat the victim for his injuries. And they left those behind.
States 19.
That's evidence placard number 1 showing casing.
States 20.
That's a close-up of the same casing, and it's showing the head stamp of the casing.
States 21.
That's evidence number 2 with another casing.
States 22.
That's evidence number 3 with another casing.
States 23.
That's evidence 4 with another casing.
States 24.
That's evidence 5 with another casing.
States 25.
That's evidence 6 with another casing.
States 26.
That's evidence 7 with another casing.
And I know that in this series of photographs, we're not seeing the head stamps with the firing pin impression, but these are all fired rounds.
That is correct.
States 27.
That's evidence number 8 with another unknown caliber casing.
States 28. What do we see here?
That's an overview of the victim, basically showing the immediate area and the medical supplies and the condition of the victim when we found him during our investigation.
Okay, and coming down kind of slightly from the victim's waist, this item on the ground, did you ultimately find bullet strikes into the concrete?
Yes, we did.
States 29.
That's a close-up photo of the victim. It's showing the belt at his waist, and it's showing that the belt was severed.
States 30.
That's the victim's cell phone that was in his pocket. It's showing that it was shattered.
States 31.
That's the front of the cell phone when we removed it from his pocket.
States 32.
This is an overview of the lower part of the victim's body. It's also showing some of the condition of the victim's body when we found it during our investigation.
States 33.
That's a close-up of the victim's right leg. It's showing the damage that we observed during our investigation.
States 34.
Those are items that were recovered from the victim's pocket during our investigation.
States 35.
That's showing the victim's identification that was located in his wallet at the time of our investigation.
States 36.
That's the contents of the victim's wallet when we were doing our investigation.
States 37.
That was when I laid out the money, indicating how much money we recovered from the victim's wallet during our investigation.
States 38.
That's another view of the sidewalk and the evidence looking towards the north.
States 39.
That's an example of some of the paperwork that we recovered around the victim at the time of our investigation.
States 40.
That's another example of paperwork that we located around the victim.
States 41.
That is also additional paperwork that we located around the victim.
States 42.
That is another paper that we located by the victim.
States 43.
Those are also papers that we located on the ground by the victim.
States 44.
Those are additional papers that we located on the ground by the victim.
States 45.
That's another view looking towards the north. It's showing the evidence that has the placard labels on them and also the condition of the victim's body.
And States 46.
That's evidence 10. It was an unknown fragment that we recovered.
States 47.
So that's showing the east wall of the Baptist Health building, and it's showing where we labeled some bullet defects to the metal molding and also to the glass that we located, and it was to the north of where we observed the victim.
Okay. And I'm circling kind of right in the middle of the picture below the tape. Is that what you're referencing?
Yes.
And you said that anytime that you find suspected bullet strikes to buildings, you will label those.
Yes, that's correct.
Same kind of question as the placards. Are you giving an order of sequencing or just the order that you found them in?
No, we're not sequencing it. We're just basically documenting it in the order that we actually do find it.
States 48.
That's a closer view. It's showing that metal molding, and it's showing some of the labels that we put on it showing the bullet defect to the actual metal molding and then also to the glass nearby.
States 49.
That's a close-up of the bullet defect to the metal molding that we labeled as B1.
States 42, or sorry, states 50.
That's the other corresponding side of the metal molding, and that we labeled as B2.
States 51.
And then that's the final area where it shows a bullet defect to the glass that we labeled as B3.
States 52.
That's an overview of the east wall of that shopping plaza, and it's showing the evidence placards, and it's showing the location of the victim's body in perspective with the Baptist primary care area.
States 53.
So that's showing, if you look at the planner on the right-hand side, at the base of the planner, we located another bullet defect, and that's also labeled there.
Okay. Is that what I've circled on the screen there?
Yes.
For the record, it's at the base of the concrete planer. States 54.
So you can see the planter in the left-hand side of the photo, and then also that's showing basically the south wall of the rest of the plaza as an overview.
States 55.
That's a close-up of the bullet defect that we labeled at the base of the planter.
States 56.
That's evidence 11, which was an unknown fragment that we located at the scene.
States 57.
So that's an overview of the east wall of the shopping plaza. Again, it's just showing the evidence placards, and it's showing the perspective and how they're related to each other.
And states 58.
That's an unknown casing, and it was evidence number 12.
States 59.
So that's a view of the shopping center looking towards the north, and it's also showing the relationship of the different items of evidence to each other at the scene.
States 60.
That's evidence number 14, and it's an unknown caliber casing.
States 61. What is the focus of this photograph?
So that's another close-up of the right side of the victim's body, and you can see the fact that the belt was severed, illustrated in that photo.
Okay. And I'm circling a couple of items on the screen. Can you tell the jury what those items are? Just for the record, they're like a cone-shaped item. Below is underwear and a couple of other metal pieces.
Yes. So we located several fragments by and under the victim's body, and the specific cone-shaped fragment appeared to be consistent with the tip from a rifle round.
States 62.
That's a closer-up photo of the object that we were just describing, the unknown fragment that appeared to be consistent with the tip of a rifle round.
States 63.
That's documenting the right hip of the victim, showing a wound that we observed at the time of our investigation.
States 64.
That's a bullet defect into the concrete by the victim.
States 65.
That's showing the victim's body was moved after the medical examiner got there and started their investigation. It's showing fragments that were located under the victim.
States 66.
That's another unknown fragment that was located in the area.
And 67.
That is also illustrating some more unknown fragments that were located in that area.
States 68. Can you explain what the yellow items that you place on the ground are that I've circled?
Yes, so after the victim's body was removed, there were bullet defects into the concrete, and the yellow markers are labeling the bullet defects in the concrete.
69.
So that's basically evidence placard A, and it's illustrating one of the defects that we located.
70.
That's evidence placard B, and it's illustrating another defect that we located.
71.
That's another overview of that same area where the victim's body was, and it's showing a third evidence placard C.
And 72.
That's a close-up of evidence placard C, which was a bullet defect into the concrete.
And the physical evidence that you collect as you are processing the scene, do you collect those items and place them into the property room?
Yes, I do.
Do you yourself do any forensic testing on those items?
No, I do not.
Your Honor, permission to approach the witness?
Yes.
And I'm showing you what's been introduced, or what's been
Yes, I do.
Can you explain to the jury what this item is?
So the part on the left are 10 unknown caliber casings, which are the evidence items that I placed in the proper room. And then the one on the right is another unknown caliber casing.
Your Honor, at this time, the state would move into evidence which is marked as states 8T and states 202.
Okay, any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, then 8T will be marked into evidence as State's Exhibit 202.
Ma'am, I'm next showing you what's been marked as states 8U for identification purposes. I'll ask you to look at that item. Can you tell the jury what that item is?
These are both unknown fragments. One was evidence number 10 and one was evidence number 11 that I collected at the scene.
Your Honor, at this time, the state would move what's been marked as states 8U and states 203 into evidence.
All right, any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, 8U shall be moved into evidence as State's Exhibit 203.
Finally, ma'am, I'm showing you what's been marked as 8V as in Victor. Can you take a look at that item?
I recognize this item.
What is that item?
They are two unknown fragments that were located on the ground under the victim.
Your Honor, at this time, the state would move 8V as in Victor into evidence as states 204.
Any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, then State's Exhibit 8V shall be moved into evidence as State's Exhibit number 204.
One moment, Your Honor.
Yes.
Thank you. I have no further questions.
Okay, any cross from Defendant Whitaker?
No, Your Honor. Thank you.
Any cross from Defendant Robinson?
No, Your Honor.
All right, may this witness be excused?
Ma'am.
Okay. Thank you, Detective. You're excused and free to go.
Thank you, Your Honor.
All right, State, you may call your next witness.
State would call Detective Grant.
Grant.
Yes, ma'am.
All right, Detective Grant, please. Oh, okay. I was looking for her on the list. All right, Detective, if you'll come forward and be sworn.
Raise your right hand. Establish your affirm testimony you give with the truth, the whole truth, and nothing but the truth.
Yes, if you'll have a seat right there, be sure to speak closely and loudly into that microphone.
Good afternoon, ma'am. Can you please introduce yourself to the jury?
Yes, my name is Rebecca Grant, previously Rebecca Crosby.
Okay. And where are you currently employed?
I'm currently retired.
Retired from the Jacksonville Sheriff's Office?
Yes, I am.
When you retired, what was your assignment at the Jacksonville Sheriff's Office?
The crime scene unit,
How long were you with the crime scene unit?
8.5 years.
And were you also what is called major case certified?
Yes, I was.
I want to draw your attention to January the 15th of 2020. On that day, were you dispatched to 1033 Townsend Boulevard?
I was.
And while there, did you learn that you were asked to process both a vehicle that was nearby as well as a home located at that address?
Yes,
Were you working with another detective on that day?
I was. I was working with Detective James.
Your Honor, this time the state would ask to publish what's been already admitted into evidence a series of photographs.
All right, you may go ahead.
Ma'am, the jury's already heard kind of from Detective Dunn about what your procedure is when you arrive on scene, but is it any different when you're processing a scene that is outside versus a scene like a home?
No, when we get to the scene, we always speak with the detective on scene.
Get an understanding of what happened,
Yes,
and then take overall photographs as well as photographs of particular items.
correct.
So we'll start with the home. I'm showing you State's Exhibit 108. Can you explain to the jury what's in this photograph?
So this is overall photograph of the exterior of the house and also to show the house number.
State's 109,
A continued overall photograph of the house.
State's 110,
This is just an overall photograph of the front door.
State's 111,
And this would be an overall photograph of the right side of the residence.
State's 112,
Again, another angle of the residence.
113,
And this is an overall photograph of the left side of the residence.
114,
Photograph of the back porch.
115,
This is the sliding glass door.
State's 116,
This is the room that, when you enter the sliding glass door, that you come into.
State's 117,
Once you enter the sliding glass door, this is where we're showing that you continue to walk through the house.
118,
An overall photograph of another room in the house, the dining room area
119,
of the kitchen.
120,
And this would be a photograph of the front door.
121,
Again, a picture of the front door.
122,
This is an overall photograph of a picture just showing the hallway.
123,
This would be the living room area before you enter into the hallway.
and if you're standing at 123 and you look out these windows, where does that lead you to?
That should be the front yard.
124,
This is the hallway.
125,
This would be a picture of the spare bedroom that's on to the right of the hallway.
126,
That would be the spare, inside the spare bedroom.
127,
Again, a picture of the hallway,
128,
showing me walking down the hallway.
129,
The closet in one of the bedrooms.
130,
This is the hallway picture showing should be a bathroom door to the left and another spare bedroom.
131,
And this was the bathroom in the hallway.
132.
Spare bedroom in the hallway.
In addition to photographing the house, were you also asked to take photographs of the resident of the house, Miss Barbara Buckley,
Yes.
showing you dates 133? Who is this?
This would be our victim, the homeowner.
Dates 134. What do we see here?
I was advised by detectives on scene that she had injuries, so this is photographing an injury to her neck.
135,
This is just a closer photograph of her injury with a scale, just kind of give it perspective.
136,
An injury to her wrist, her left wrist.
and 137.
Again, the same thing, just a scale, just to give it perspective, the size of the injury.
Ultimately, are you going to take a swab of her neck and her wrist?
Yes.
States 138,
This is a photograph of her hands.
states 139,
This is showing that she has possible blood on her hand, her thumb.
and 140. Is that what we're talking about?
Yes,
141, her hands again.
again.
142,
Just another injury to her right arm.
143,
Again, just with scale to show the perspective of the injury.
143. This should be 144.
This is an overall photograph of her pants, the back side of it.
It's what should be 145.
That's to show that there's possibly what we think is blood on her pants.
Okay. And when you suspect that there's possibly blood on an item like pants, is there something that you can do to test for that?
Yeah, so we take a sterile swab, we hydrate it with distilled water, and we swab the area in question, and then we conduct a hemodynamic test that, once you stick it in that test kit, it will turn blue if it's a positive reaction.
What should be 146
Again, just showing the area that we're focused on.
and 147. Is that the hemodynamic test?
Yeah, so that would be the reaction that we got.
Ultimately, we talked about the fact that you did a swab of her neck and her wrist. I can have a moment of time. I'm showing you this marked as State's Exhibit 9L for identification purposes. Can you tell me if you recognize that item?
Yes.
What is that item?
This would be the touch DNA swab that we took of her neck and her left wrist.
Your Honor, at this time, the State will move into evidence which is marked as 9L as 220.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, 9L shall be marked into evidence as State's Exhibit 220.
Showing you it's been marked as 9K for identification purposes. Recognize that item?
Yes. These are 2 buccal swabs that we collected from Mrs. Buckley.
Can you explain to the jury what a buccal swab is and how you take it?
So a buccal swab is basically we take sterile swabs and we swipe the inside of the mouth. And it's basically a comparison swab of the DNA that we collect.
Your Honor, at this time, the State will move into evidence which is marked as 9K as states 219.
Okay, any objection from Defendant Whitaker? Any objection from Defendant Robinson? All right, 9K will be moved into evidence as State's Exhibit 219.
Detective, ultimately, did you collect the shirt and pants from Ms. Buckley?
I did.
I am showing you first what has been marked as State's Exhibit 10K. Recognize this item?
Yes.
And what is this item?
This was the shirt that was given to me on scene by Detective Richardson.
The shirt was seen in photographs.
Yes.
And State would move this into evidence as states 244.
Okay, and any objection from Mr. Whitaker? Any objection from Mr. Robinson? All right. State's Exhibit, what exhibit is this?
244 now. It was identified as 10K.
10K, okay. 10K shall be moved into evidence as State's Exhibit 244.
States 10L.
Yes, those were the pants she was wearing.
Your Honor, the State would move into evidence which is marked as states 10L as states 245.
Okay, any objection from Mr. Whitaker? Any objection from Mr. Robinson? All right, 10L shall be moved into evidence as State's Exhibit 245.
In addition to processing the home of Ms. Buckley, Detective, you were asked to process the crashed vehicle that was somewhat nearby.
Yes, I was.
I can have a moment. Showing you State's Exhibit 73. What is State's Exhibit 73? Can you see that on your screen?
Yes.
What do we see in this photograph?
So this is the numeric of the residence the vehicle was located.
State 74.
Just an overall photograph of the area where the vehicle is located.
State 75.
Again, an overall photograph.
State 76.
This would be an overall photograph of the vehicle as we found it.
State 77.
Overall photograph of the vehicle and the damage.
State 78.
Overall photograph of the vehicle and the license plate.
State 79.
Another overall photograph of the vehicle.
State's 80.
And an overall photograph of the vehicle and the damage.
State's 81. What do we see in this photograph?
This is a picture showing that the gear shift is still in drive.
When you arrived on scene, was the vehicle still turned on?
Yes,
Who turned the vehicle off?
I did.
State's 82. What do we see here?
So this is a photograph of the exterior looking inside the vehicle of what's in the driver's seat.
You said that at this point, you're taking photographs from the exterior of the vehicle.
Correct.
You're still on scene at this point.
Yes.
Ultimately, are you going to have the vehicle towed to the JSO warehouse?
Yes, we are.
And what's the point of doing that?
To have a more secure location and then also to get the search warrant.
Okay. When you move a vehicle from one scene to the warehouse, is there something you do to secure the vehicle to make sure that it's not tampered with?
Yes, so we seal the vehicle, all points of entry, with evidence tape with our names, the date, and the report number.
All right, so states 83.
So this is also an exterior picture looking in, showing a rifle in the back seat.
And states 84. We've now moved to the warehouse.
Yes, so this is our warehouse, just showing an overall picture, trying to document that the seals are still placed.
Okay. And I'm circling kind of in the middle of the screen, a blue sticker on the hood of the car. Is that what you're referencing?
Yes.
Were any of the seals tampered with?
No.
States 85.
Again, to show the seals were still in place.
States 86.
This would be an overall photograph of us, of the interior of the vehicle.
States 87.
Overall photograph of what we found in the driver's seat.
States 88. What is that?
It was a white T-shirt,
States 89.
and this is to show the make and size of the T-shirt.
This is the one that's in the front seat.
I'm not sure which one this is.
States 90.
This would just to show overall photograph of the glove box area in the center console.
And ultimately, you're taking your photographs in series.
Yes.
States 91.
This is an overall photograph of the left rear passenger area.
States
Or,
92. I'm sorry.
sorry, right rear.
States 92.
Again, overall photograph.
States 93.
Overall photograph of the area.
States 94.
And this would be the overall photograph of the other T-shirt.
States 95.
An overall photograph of then the left side of the vehicle.
States 96.
This is the overall photograph of the trunk of the vehicle.
States 97.
This is an overall photograph of the Glock that we collected in the driver's seat.
States 98.
This is to document the identification of the gun that we located.
States 99.
This is to show that there was an actual live round that was in the chamber of the gun.
States 100.
This is the live round next to the magazine of the gun,
States 101.
and that would be the live rounds located in the magazine of the gun.
States 102.
Overall photograph of the rifle that we found.
States 103.
This is to document that the rifle was actually in fire mode and not safe.
States 104.
This would be the live round that was located in the chamber of the rifle.
States 105.
This is to show the stamp head of the live round.
States 106.
Again, this is identifying the type of rifle it is.
And States 107.
And these are the live rounds that were located in the magazine of the rifle.
In addition to photographing and collecting evidence from inside the vehicle, do you also take swabs of the compartments of the vehicle?
Correct.
Can you explain how that's done?
So it's the same process. We take a sterile swab and we hydrate it with distilled water, and we break down the vehicle in 4 compartments. And those 4 compartments would be the driver's side, the left rear side, the front passenger side, and the right rear passenger side.
And how do you divide up the passenger side from the driver's side?
So we tend to swab, for example, the driver's side, we swab areas that are common for a driver to touch, such as steering wheel, gear shift, door handle, those type of areas.
That also include the center console of the vehicle.
Yeah, so we would split those in half and do one side here and then one side on the other side.
Understood. If I can have a moment. Showing you what's been marked as states 9M for identification purposes. Can you take a look at that?
Yes,
What is that item?
it would be a touch DNA swab of the driver's compartment.
This is the one that you performed in this
Yes.
Your Honor, at this time, the state will move into evidence between Washington State's 9M as State's 221.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, the 9M shall be moved into evidence as State's Exhibit 221.
Next, showing you what's been marked as State's Exhibit 9B. Take a look at that item. First, the brown bag that I've just kind of pulled out of the side. Could you explain what the brown bag is?
It's basically a way to, the item, to collect the item without contaminating the item.
And this is what goes into the property room?
Yes.
And on the brown bag, do you write what is inside of the bag?
Yes, we do.
First, can you take a look at this item on the bag?
Yes.
Do you recognize this item?
Yes, it's the white T-shirt collected from the driver seat.
Your Honor, at this time, the state will move into evidence which is marked as State's 9B, as State's 210.
All right, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
All right, 9B shall be moved into evidence as State's 210.
Next, showing you what's been marked as State's 9C, as well as the back of it. Tell the jury you recognize this item.
Yes, so this is the white T-shirt that was in the rear back seat in the middle.
Your Honor, at this time, the state will move into evidence which is marked as State's 9C, as State's 211.
All right, any objection from Mr. Whitaker? Any objection from Mr. Robinson?
No, Your Honor.
All right, 9C shall be marked into evidence as State's 211.
Your Honor, the next exhibit states 8Z, which is a rifle, I believe it's been cleared by the bailiffs.
Okay,
And we're showing you what's been marked as State's Exhibit 8Z. You recognize this item.
Yes.
What is this item?
And that would be the rifle located in the back seat.
Your Honor, at this time, the state will move into evidence which is marked as State's 8Z, as State's 280.
okay, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
All right, State's 8Z shall be marked into evidence as number 208.
Just quick permission to publish, Your Honor.
Okay.
Showing you what's been marked as State's Exhibit 9A. You recognize these items?
Yes, those are the live rounds located in the rifle.
The rifle that we just saw.
Yes.
The state will move into evidence what's been marked as 9A, as State's 209.
Any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, then Exhibit 9A shall be marked into evidence as 209.
When you collect an item like a rifle, do you process it or do you swab it to potential DNA?
Yes, we do.
Can you explain how that's done?
So again, the same process, take a sterile swab, hydrate it with distilled water, and then we swab the areas rough, like with a rough exterior Usually it could be the magazine, the slide. I mean, it's according to what type of gun it is.
Something like a smooth surface, like the slide of a handgun, can you swab that item and leave that for potential fingerprint examination?
So no, we wouldn't swab that. That would be for possible latent prints.
Showing you what's been marked as State's Exhibit 8W. That item.
That would be the Glock that was located in the driver's seat.
Your Honor, the state will move into evidence what's been marked as State's Exhibit 8W as State's Exhibit 205.
Okay, any objection from Mr. Whitaker?
No, Your Honor.
Any objection from Mr. Robinson?
No, Your Honor.
Okay, without objection, State's 8W will be marked into evidence as 205.
And the same thing with this is the rifle. You can swap with the same procedure.
Correct.
Smooth items available for examination.
Right.
Showing you what's been marked as State's 8Y and 8Z, or 8X and 8Y. You look at these two items.
Yes.
What are these two items?
These would be the .40 caliber live rounds that were located in the handgun.
Your Honor, the state will move into evidence which been marked as 8X as State's 206 and State's 8Y as 207.
Okay, any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
Okay, so State's Exhibit 8X shall be marked into evidence as number 206, and State's Evidence XY shall be marked into evidence as State's 207.
Thank you, ma'am. I have no further questions.
All right, is there any cross from Defendant Whitaker?
Yes, Your Honor, very brief.
A.
Which stocks do you need the photographs?
Yes, I need,
96, from the vehicle or the home?
yes, 96.
96.
Detective, just a few very brief questions. Did you make any effort in regards to this Altima? It would turn over, like when you got it to the police impound yard, were you able to crank up the engine again?
We don't crank it up again.
I've seen in past cases, was there any effort made to determine if anyone had ever connected a cell phone to the car? You know, with Apple Play, CarPlay, anything like that?
Not to my knowledge.
Then in regards to what's now been stipulated as State's 96, did you do any kind of fingerprint analysis on this item?
I did not.
Okay. Once you take all of your photographs, those are automatically forwarded to the lead detective in the case, correct?
Well, it's sent off to our print lab, who then, he has to get a copy through them.
Okay. Because obviously that's something the lead detective is going to do. That's why you make every effort to meet with either the lead or one of the detectives so that you can kind of determine where should I be focusing on, correct? And you make sure that your reports and really the Jacksonville Sheriff's Office does it, correct? They make sure that all of your reports and all of your photos are readily accessible to those detectives because they kind of have the bigger picture, right?
Correct, they have access to those, yes.
And of course, that was done in this case.
Yes.
I don't have anything further, Your Honor. Thanks.
All right, any cross for Mr. Robinson?
Briefly, Your Honor, yes. Good afternoon, how are you?
Okay, good.
So, question with respect to the swabbing of the interior of the vehicle, okay? You were saying that you use one swab per compartment?
Yes.
All right, so for instance, if you're in the driver's seat, you're going to use one swab for the steering wheel, the seat belt buckle, the center console. Is that the way that it's done?
Correct.
All right. Does that lead to the potential of combining DNA? If you have two contributors, one on the steering wheel, one on the seat belt, would that create a mixture?
Possibly, but it's a better proponent to collect more DNA with one swab.
I'm sorry?
It's a better to be able to collect more DNA with one swab in one compartment area, yes.
One moment, Your Honor.
Okay.
Nothing further. Thank you, ma'am.
All right, is there any redirect?
No, ma'am.
May this witness be excused?
Yes, ma'am.
All right, thank you, Detective. You're excused and free to go.
Thank you.
Your Honor, can we take a short recess to confer with which witnesses we have available for the rest of the afternoon? Oh, okay.
Ready? All right, call your next witness.
Emily, Anna here.
I'm sorry, who?
Emily, Anna here from Florida Department of Law Enforcement.
Okay, thank you. All right, ma'am, if you'll come forward and be sworn. All right, if you'll be certain to speak closely and loudly into that microphone, thank you.
May it please the court.
Yes.
Good afternoon. Please introduce yourself to these two juries.
Yes, my name is Emily Amihere. The first name is spelled E-M-I-L-E-E, and the last name A-M-I-H-E-R-E.
And ma'am, I'm going to ask you to just pull that microphone a little bit closer to you to make sure everyone hears you. You got to project with two juries here. Thank you. What do you do for a living, ma'am?
I'm currently employed at the Florida Department of Law Enforcement in the Jacksonville Regional Operations Center as a crime laboratory analyst in the firearms section.
How long have you been so employed?
I've been with the department in total a little over 12 years now.
And how long have you been in the firearms unit?
I've been in firearms for approximately 10 years or so, in the last 8.5 or so as a qualified analyst.
So give the juries an idea of how you came to get this job, your training and experience, and then what you do at the Florida Department of Law Enforcement.
So I have a bachelor's degree from the University of Florida, as well as a master's degree in crime scene investigation forensic science from the George Washington University as my educational background. And then at the Florida Department of Law Enforcement, I completed their in-house training program, which is approximately 16 to 17 months for crime laboratory analysts in the firearms section.
Do you receive training once you're hired by the Florida Department of Law Enforcement that helps you perform the duties that you're here to testify about?
Yes.
And describe that a little bit for the jury.
So the training program for crime laboratory analysts in the firearms section, again, is approximately for me was about 16 to 17 months, which includes 2 phases. And those are going to include academic study and experimental and comparative study of all the subject matter that a crime laboratory analyst will encounter in independent casework. So these would be things like history of firearms and ammunition, working mechanisms of firearms, how to disassemble and compare fired components, usually bullets and cartridge cases, but also including shot shell components that an analyst will encounter in casework. So again, the training occurs in 2 phases. and each phase will culminate in what's called an oral board examination, which is approximately 2 to 3 hours with the trainees training committee, which consists of all qualified analysts in the firearms section, and those have to be passed before you can move on to the next phase. The second phase is much like the first, but also includes a period of supervised casework, which is approximately 800 hours, which usually works out to about 5 to 6 months, where an analyst trainee will work cases under the supervision of a qualified analyst in the section. Once all of that is passed, and trainee will be given their mock case to work independently and testify to their findings in a moot court setting. And again, once all of that is passed, they'll be able to be signed off and authorized for independent casework in the firearms section.
So we've mentioned firearms. What are the types of things that you would testify to in a court using your training, education, and experience?
Primarily, the duty of a firearms examiner is to examine, microscopically compare fire components, usually bullets and cartridge cases, to each other if no gun is submitted in a case, or to a specific firearm if a particular gun is submitted in a case, to see if they were fired from the same source.
In addition to that comparison, when you're looking at fired components, are you also generally an expert in firearms generally?
Yes, I've been qualified as an expert, yes.
And approximately how many times have you come into courts like this and provided your opinion with regards to what you've just testified to?
Approximately over 50 times at trial, and then other depositions and hearings as well.
Your Honor, I would this time tender the witness is able to give her opinion in the field of firearms and the ballistic testing that she does.
Okay, is there any additional voir dire either Defendant Whitaker or Defendant Robinson wishes to conduct?
Can't argue that experience, Your Honor. No
Okay, thank you. Go ahead, Mr. Mizrahi.
So let's explain a little bit. We mentioned FDLE. The jury hasn't met anyone from FDLE yet. What is the Florida Department of Law Enforcement, and how does it interact with the Jacksonville Sheriff's Office, the State Attorney's Office, things like that?
Very simply, the Florida Department of Law Enforcement encompasses a state law enforcement agency that has both a forensics and investigative side to aid local, county, and city law enforcement, in my particular case, in forensic services.
So you're in the firearms unit. Does the Florida Department of Law Enforcement also have a DNA unit?
Yes, they do.
And are those separate?
Yes, they are.
Okay, so you're not going to come and testify about DNA, and they're not going to come testify about firearms.
Yes, I have no training in DNA at all. All I do is firearms.
And I would now turn your attention. Do you have your case file with you?
Yes, sir.
And have you prepared for this testimony and reviewed it?
Yes.
If you ever need to refer to it, please feel free to do so. That's fine, okay?
Okay.
And that's going to be in your FDLE number 2020-04626?
Yes, sir.
And did you receive a series of items purported to be either things that came out of a firearm and then 2 firearms?
Yes, there were components as well as 2 firearms submitted in this case.
So I want to first talk about things that just ended up being inconclusive because we don't need to spend a lot of time on it. Did you receive a number of fragments of what was purported to be fired bullets?
Yes, there were numerous projectile evidence items in this case, including some fire bullets.
And were those of any value for you to compare to any firearms?
Specifically, several items were no value. I can name those if you'd like.
I don't think we need to. I think let's go to this. Is it common that when you have a projectile crash into concrete and walls that it gets so deformed that it's of no use for comparison?
Yes, that does happen.
Did you also receive a series of shell casings?
Yes, there were also cartridge cases submitted.
Okay. Explain to the jury the difference between these fragments / bullets and what a cartridge case is.
So very simply, a cartridge case is just the metal receptacle that holds all the components of unfired ammunition, otherwise known as cartridges. So those components are going to be the bullet, the cartridge case itself, the primer, and the gunpowder. So once a round is discharged in a firearm, those first components, the primer and the gunpowder, will be consumed by the detonation, and the bullet will use those products of that detonation from the primer and the gunpowder to be propelled down the barrel of a firearm. So that will leave the barrel of a firearm toward whatever the target was in the shot, and the cartridge case itself will be ejected from the firearm usually in a semi-automatic fashion.
Okay. And so like in a revolver, those cartridge cases would remain in the firearm until they're somehow manually expelled.
Yes.
But in a semi-automatic or an automatic, they would automatically be expelled from the firearm.
Yes, sir.
In your training and experience, is it common to be able to match one shell casing to another shell casing to determine whether or not those two shell casings or cartridge casings were fired from the same firearm?
Yes, the comparison of cartridge cases to each other is an examination that I will perform quite often.
Are you able to link cartridge cases to bullets that go down the barrel?
So cartridge cases and bullets that are expelled down the barrel of a firearm will be two separate components. So comparing the cartridge case to the bullet that has been fired is not an examination that we can practically do because the marks from the inside of the cartridge case will be obliterated, that will be on the bullet would be obliterated by its travel down the barrel. So the only thing that we can do is compare cartridge cases to cartridge cases and bullets to bullets.
Are you also able to do bullets and cartridge cases to firearms that you have?
Yes.
Okay, and you did that in this case.
Yes, that was the request.
Are you also able to test the functionality of any firearms that you received?
Yes.
All right, so let's quickly go through the various items that you did, and we're going to begin with the cartridge cases. May I approach the witness, Your Honor?
Yes.
And these have already been introduced into evidence. Showing you what's been entered into evidence, it states 202. Do you see that?
Yes, sir.
And how do you recognize it?
If I may. By the unique FDLE case number, the item number on the packaging, as well as on the cartridge cases.
Is it the yellow sticker?
Yes, the yellow label on each of these packages is from FDLE, and those items will be affixed with those labels as soon as they are submitted to the laboratory.
Okay, so we see a series of, 10 cartridge casings in one, and then one cartridge casing in another, and they have separate numbers. One is number 24, and then one is number 1. You see that on there?
Yes,
Why are they separate?
because those were two separate numbered items that were submitted.
Were you able to do a comparison of all these shell casings to each other?
Yes.
And what were your findings?
I came to the opinion in the comparison of these two cartridge case items, the total of 11, that they were identified as having been fired in the same firearm.
During the course of your examination, were there any cartridge casings that did not match these 11 cartridge cases?
No, again, the item identification opinion was for those cartridge cases to each other.
I'm showing you what's been entered into evidence. It states 205. Let's see if we can find your sticker. Do you see that?
Yes, sir.
And did you examine this rifle?
Yes.
Are the cartridge cases that we just talked about, could they possibly have been fired from this rifle?
Since the rifle and the cartridge cases that were submitted in items 1 and 24 were of the same caliber, they could have been fired in that firearm, which is why I had to compare tests from that rifle to the cartridge cases that were submitted.
For example, if the only firearm that you received was the .40 caliber, you wouldn't have even done the comparison because there's no way those cartridge casings could have been fired from a .40 caliber handgun.
Yes, that's true. That's what we would call an elimination on class characteristics, the class characteristic being the caliber.
So when you did the comparison, were the cartridge cases fired from the rifle?
I came to the opinion that they were not. So that was an elimination opinion of the item 1 and 24 cartridge cases as with respect to that rifle.
Was the rifle operational?
Yes, it was functional at the time of my examination.
And you actually did a test fire?
Yes, I did.
Likewise, did you have any cartridge casings to examine and compare to State's Exhibit 205, the .40 caliber? I guess you need to look at that as well. May I just approach freely?
Yes.
Yes, I examined that firearm, and there were no 40 S&W caliber cartridge cases submitted to me with these items.
Was that firearm, the 40 caliber, functional?
Yes, it was.
Did the laser sight on the gun work?
At the time of my examination, I found it to be non-functional.
I also want to show what's been pre-marked as State's Exhibit 9D. Did you examine one bullet that was potentially able to be made a comparison able to be?
Yes, I examined this bullet.
And why did you begin the examination? Is it because there was characteristics on it that you could potentially match?
Yes, the first part of any examination is judging the suitability of the item, whether there are any marks that could be compared to anything at all. And I found this item to be somewhat suitable for comparison, which is why I ended up comparing it in this case.
And did you note that that had come from the medical examiner's office?
The envelope in the packaging that was submitted to me did state that.
And what did you notice about this fired bullet?
As far as the conclusion?
Well, yeah, what were the characteristics of it? What was the conclusion?
So the characteristics as far as the caliber class, I found from the measurement and size of the bullets that I took that the bullet was 22/5 millimeter caliber class.
And were you able to link that bullet to any of the firearms that you examined?
No, my opinion was inconclusive based upon the examination of the bullet to the rifle in this case.
And you already previously testified how you don't compare bullets to cartridge casings, but is it consistent with the cartridge casings, this bullet?
So the caliber class of the bullet, 22/5 millimeter caliber class, would be consistent with the caliber of the cartridge cases, which was 223 Remington /5.56 millimeter NATO caliber cartridge cases.
There may be later evidence in this case about an XTAR EXP 556 MK1. Were you asked to do some research on that type of firearm?
Yes.
And that type of firearm, can you describe it for the jury?
So it's an AR style pistol, just the general description of the type of firearm made by a company that is now discontinued called XTAR, and that is a same caliber 223 Remington /556 NATO caliber that is similar to the rifle here in this case as far as the caliber.
Okay, so you're not, obviously you didn't get one of those guns to compare,
No, I did not.
and you can't make any comparison about whether the cartridge casings and/or the fired projectile came from that type of gun. Is that fair?
No, I couldn't. I would need to see the item.
But is it possible that they did?
Just based on the class characteristics, that being the caliber, that they are similar, that would be a comparison I would have to do if the item were ever submitted.
But unlike the 40, which you can immediately rule out, that type of firearm could fire what we have in this case.
Yes, the XTAR 556 could fire a 223 Remington 556 caliber round.
Thank you. That's all. Well, let me move into evidence if there's no objection from council's 9D into evidence as 212.
All right, is there any objection from Defendant Whitaker?
No, Your Honor.
Any objection from Defendant Robinson?
No, Your Honor.
All right, we'll move States 9D into evidence as States 212.
Thank you, Your Honor. That's all.
Okay, any cross from Defendant Whitaker?
Briefly, Your Honor, may I pitch the witness?
Yes.
I'm going to show you, ma'am, how you,
I'm doing well.
I'm going to ask you to take a look at Exhibit 208. And you examined this?
Yes, again, my tag here with the FDLE case number, item number, and my initials, as well as on the firearm is there.
And when you receive a firearm like this, you may assume it's fireable, but you actually tested yourself to figure out if it's operational or not, correct?
Yes, all guns would need to be function tested and test fired to see if they're operational.
And this particular gun was in fact operational.
It was.
Now I'm going to show you Exhibit 205. It should be the same with this firearm.
Yes, the examination for any firearm would generally be the same to test for functionality at the bench and then also attempt to test fire.
So if someone wanted to intend to shoot either one of these firearms, they absolutely could.
Yes, I found them to be functional at the time of my examination.
I don't have anything further, Your Honor.
Okay, thank you. Cross for Defendant Robinson.
Please, Your Honor. Good afternoon. How are you?
Good afternoon.
It's good seeing you. You work with the Florida Department of Law Enforcement, correct?
Yes,
And that's referred to as FDLE.
yes,
You're a gun expert within FDLE,
yes, I work in the firearm section.
and you've testified as an expert on firearms dozens of times before, correct?
Yes, I've been qualified to do so.
Now, I'm not going to get into specifics here, so feel me out on this question first. You make a salary through FDLE, right?
Yes, my salary is paid by the state.
Whether you're in here testifying on this case or you're back at FDLE testing items on another case, your pay is the same, right?
Yes, it is.
Meaning that you're different than a private contractor expert that's hired and paid specifically for their time and testimony on a case, right?
Yes,
Right. Now, you were asked a question about the X-Tar. What's the name of that gun?
I believe it's the EXP 556.
All right. Now, you said that was a company that recently ceased to exist, right?
As I've researched it, it's been discontinued,
All right. So in 2020, that company was in existence, correct?
as far as I've researched.
And it was sometime in between then and now that they stopped producing the firearms, specifically the one that you just mentioned, right?
As I research, yes.
All right. If a company were to go bankrupt, cease to operate, and stop manufacturing the guns, would that then make the gun rare?
I don't know exactly how many they sold or how rare the firearm might be.
All right. Now, you as the firearm expert working for law enforcement, did the government ever come to you and show you a photograph of a third firearm and ask you as the firearm expert to identify that gun?
Identify the gun from the photograph.
Correct.
I was showed a photograph during a pretrial as far as a model that they wanted me to look at, and that was it.
And they never, the pretrial was before charges were filed back in 2020?
It was just recently this year before testimony in this case.
One moment, Your Honor.
Okay.
Nothing further, Your Honor. Thank you, ma'am.
All right. Is there any redirect?
No, Your Honor.
May this witness be excused? All right, thank you, ma'am. You may step down, and you are excused and free to go.
Thank you.
We have another shorter witness.
We have a civilian, and we have the FDLE people are still here, but we're going to take a civilian real quick.
Okay, and it's a short witness? Okay, it's just for the jury, so we'll do this one witness, and then we'll take an afternoon recess. Just wanted to get the timing of it all. So state you call your next witness.
This David call Ms. Ronaldo Boston.
All right, Ms. Boston, please. All right, ma'am, if you'll come forward and be sworn. No, all the way up here. Thank you.
Establish law firm testimony to give the truth, the
All right, and be sure to sit up close to that microphone and speak loudly and clearly into it. Thank you. You may proceed.
Thank you, Your Honor. Ma'am, will you please introduce yourself to the jury?
My name is Ronaldo Boston.
All right, can you sit up a little closer to the microphone? Thank you. Or you can pull the microphone closer to you.
Ms. Boston, do you live in Jacksonville?
Yes,
How long have you lived in Jacksonville?
my whole life.
I want to draw your attention to January of 2020. Back in 2020, where were you living?
In Lake Chateau.
Okay, and that's an apartment complex?
Yes,
And is that at 7201 Arlington Road?
yes,
Do you remember a day back in 2020 in January where there was heavy police involvement, contact out in the area?
yes,
And you were getting notification alerts on your phone?
yes,
I'm showing you what's been marked as states 248. Do you see that on your screen?
yes.
And ma'am, can you, by touching the screen, show the jury where you were on that day, approximately?
Here.
Okay. And for the record, you've kind of drawn it in between where it says 7201 and another building 7201, and there's kind of a white truck and a gray car there.
Yes,
And at some point during the day, were you outside talking with your neighbors on what you call the wall?
yes.
Can you explain to the jury what the wall is?
When I come out my apartment, it's a set of stairs, and on the stairs, it's connected to a wall, and you can sit there.
Okay, you can kind of see it on the map there,
Yes,
and I'm showing you States Exhibit 180. Sorry, is that a fair representation of the wall?
yes,
Okay, and you said you have to come up a set of stairs to get out from the apartments?
yes.
Do you remember what time of day it was that all of this was going on?
It was like, late in the morning, early afternoon.
Okay. Now, where the wall sits, is it, when it butts up to grass, is it just where the sidewalk ends and the grass starts, or is there an elevation difference?
It's elevation difference.
Okay, so it's not sitting straight up, but there's some difference. And what is higher, the grass or the wall?
The wall is higher,
Okay. How much is the wall higher than the grass?
a few inches.
A few inches?
Feet, like a few feet.
A few feet. Okay, so if I start with my hands where they're equal, I'm going to kind of demonstrate, and you tell me when to stop, approximately when you think that it is, okay?
Like that's,
About there?
yes,
Okay, and how much would you estimate that is, just kind of looking at it?
probably like a feet or two.
A foot or two? At some point while you're standing there, do you hear something from behind you in the woods?
Yes,
And going back to the map, you said that you're about here. Is this the woods here where I'm drawing on the map?
yes.
And what is it that you hear?
We were talking and I heard like scrubbling, like a sound, like a trash bag kind of rattling sound, like leaves.
Okay, like a rustling of leaves?
Yes,
All right. At some time around the time that you hear that noise, do you see something else that draws your attention?
yes.
What is that?
A car
Okay.
approaching us, like coming the way we were sitting.
And what was significant about the car?
It was a lady driving, holding a cell phone. She looked lost, like she was looking for something.
Okay. Do you remember what she looked like?
Yes,
Remember what race she was?
yes.
What was she?
She was white.
Okay. Had you ever seen her before in that complex?
No,
And at that point back in 2020, had you lived there for some time?
yes,
Kind of knew most of the people in the area?
Yes.
You had never seen her before.
No.
Do you remember what kind of car she was driving?
Like a silver four-door sedan.
At some point after seeing the sedan, do you see somebody come out of the woods from behind you where I've drawn on the screen?
Like moments after the car had passed. I did.
And can you describe that person to the jury the best that you remember?
Just the build of the person.
Okay. About how tall did he appear to you?
Maybe like he was 5'8", 5'9".
Okay. What about his build?
He was slim.
You remember about how much you guessed that he weighed?
Maybe like 160, 170.
Did you get a view of his skin complexion?
Yes.
And how would you describe that?
But a pecan brown.
Okay. Could you see his hair at all?
Yes.
What did that look like?
He had dreads.
And how long were his dreads?
It was to his chin.
Do you remember what he was wearing?
I remember the top.
Okay, what did that look like?
A gray hoodie.
How long do you think that you saw this person for?
Seconds.
And what did you do when you saw that person come from the woods?
I ran.
Okay. Did you ever see them again?
No.
Did you ever see what happened with the white woman in the silver sedan?
No.
Eventually, the police came out to the complex,
Yes.
and they spoke with you.
Yes.
Thank you, ma'am. I have no further questions.
All right, cross from Mr. Whitaker. All right, any cross from Mr. Robinson?
Squats, do you need these photographs at all?
I'll let you know.
I'll leave them, of course.
Good afternoon, Ms. Boston.
I don't know.
Okay, so this happened all the way back January 15th of 2020, right?
Correct.
You were living in that apartment complex at the time,
Yes.
and that apartment complex has cameras, right?
No.
It does not?
No.
You were sitting on that wall, you weren't sitting by yourself, were you?
No.
You were sitting with two other individuals, right?
3.
Three others. Okay, Claudia was one, right?
Yes.
Marva was one,
Yes.
and you're right, and Larry was the other one.
Correct.
Okay. They were all sitting on the wall where you were sitting.
Yes.
Were they all sitting there when the person came out of the woods?
Yes.
Okay, they saw him too?
No.
They didn't.
No.
How do you know?
Because we were all talking and I stood up. Like I had heard the sound 3 times, and like my 3rd time hearing it, I stood up and turned around, and the view was in the opening where I was sitting. They were sitting more so behind this building where they couldn't see what I saw.
Okay. But what you just stated was you were sitting on this wall, right?
Yes.
Okay. And I know that Mr. Atkinson got up here and talked to you about the fact that there's some elevation on the wall, right?
Yes.
And you can see that the state's attorney's office has pictures of the apartment complex, right?
Yes.
They could have easily taken a picture of the elevation that you described, right?
Right.
But you haven't seen one of those, have you?
Not.
Okay.
in this.
You do not know, you haven't yourself gone out and measured the height of that wall, have you?
No.
You didn't measure the level of that elevation, have you?
No.
Okay. And so you did mention, though, that you were first sitting down, and then after you heard that sound, you stood up, right?
Correct.
So you made that observation from a standing position, correct?
Correct.
Okay. And just to reiterate, the individual that you saw, male or female?
It was a male.
Okay. 5'8" to 5'9"?
Yes.
And you used the word slim, right?
Yes.
Okay. And the weight range you gave was 160 to 170 pounds.
Correct.
Okay. And I hate to do this. I don't normally ask people this, but for example, how much do you weigh now?
I wear like 180.
Okay. The description you gave as a skin color was butter pecan brown.
Correct.
Okay. And that's lighter than your complexion, correct?
Correct.
Right. And Now, also, you were able to take note of the fact that this individual was wearing a gray hoodie,
Yes,
but the hoodie was down.
yes,
Okay. The individual's hair was down, correct?
it was just loose.
Loose, okay. But in dreadlocks is how you described it,
Yes,
okay? And you said the length of the dreadlocks of that individual went down to their chin.
yes,
Okay. The hood was not covering this individual's face, was it?
no,
Okay. The bottom of this individual's face wasn't covered, was it?
no,
Okay. And then you immediately said, now you see this person coming out. Did they have a firearm in their hands?
no.
Okay. And the reason that you took off running was what?
Before that, we had got an alert to the phone stating that a murder had happened and what the individual was wearing. So I was asking the police, like, if it happened down there, why would they be down here? Like, why y'all got us?
Like almost like it was so far.
Yeah,
Okay. The information you got, in your opinion, seemed far from where you were.
yeah,
Okay. And then so because of that, that's what kind of made you take notice of this individual.
yes,
Okay. And because you received the information that it was possibly related to a murder, you just safety took off running.
exactly.
Okay. Now, now on that day though, you spoke to law enforcement, right?
Yes,
And you were able to tell them exactly what you saw,
yes,
and I'm sure they asked you a description of the individual, right?
yes,
Now, you also then remember about 2 years later, receiving a subpoena to come in for a deposition, right?
yes,
And it was over Zoom,
yes,
okay, and all the attorneys were there, right? You remember that?
yes.
Prior to that, had you met at all with the state attorney's office?
I don't remember.
Okay. And then the next time that you've spoken to anyone about this is today in court, right?
Correct.
Okay. Did you meet with the prosecutors within the past few weeks before you testified today?
Yes,
Okay. And what, you went to their office, they asked you to come in so you could sit down and go over evidence?
yes,
Did they show you your deposition transcripts?
yes,
So you could remember what you told us back then, right?
correct.
Okay. And nothing's changed. Everything that you said back then is the same as you've said today, right?
Yes, ma'am.
Okay. And then the other thing that they brought out was that something caught your attention about a car that came into the complex,
Yes,
right?
ma'am.
You noticed what you described as maybe did you say a silver sedan?
Yes, ma'am.
Was it 4 doors?
Yes, ma'am.
Okay. And you noticed that there was a woman inside,
Yes, ma'am.
and you described her as a white lady,
Yes, ma'am.
dirty blonde hair?
Yes.
Okay. And you said this was someone you had never seen before.
No, ma'am.
Now, you gave the opinion as the person looked like they were lost.
Yes.
What made you think that?
Just the way she was looking. She looked lost.
Did she look like she was looking
Looking
around?
around, yeah.
Now, you had
She had a
mentioned she
phone
had
up.
I'm sorry.
She had a phone up in her hand, and she was just like looking from side to side.
Okay, so let me ask you this. When she said she had a phone in her hand, right?
Yes.
Could you physically see the phone in her hand?
Yes.
Did she have it to her ear, or she
No.
was looking at it?
She just had it up, and she was driving.
Okay, so did it look as if she was trying to pay attention to the phone and what she was doing?
I'm not sure. I just seen the phone in her hand.
Okay. Did it look as if she was talking?
No, she was looking.
Okay. And did you see where that car ultimately came to a stop?
Yes.
Okay. Did it park?
Yes.
And did you see that suspect or individual jump into that vehicle?
I did not.
And that's just because you turned around and took off running?
Exactly.
Okay. Now, after that, because you had initially told the police that you had seen the shooter, right?
I said
Or
I
the
seen
suspect,
someone come.
I apologize. You saw the suspect coming out of the woods.
Yes.
Okay. Did they ever come back to you and try to show you any photographs?
No.
Thank you, Ms. Boston. No further questions. Thank you, Your Honor.
All right, thank you. Any redirect?
Just briefly. Ms. Boston, you said that you saw the individual that came out of the woods for a brief second or two.
Yes.
Do you think that you would have been able to identify anybody in photographs?
No.
Okay. No further questions. Thank you.
May this witness be excused?
Yes, ma'am.
All right, thank you, Ms. Boston. You're excused and free to go, ma'am. All All right, ladies and gentlemen, then at this time, it's just 3:01. I'm going to ask you to leave your notepads on your seats. Again, we will secure them, return them to you when we reconvene after our afternoon recess. If we can take approximately 15 or so minutes to give you a bio break, then we'll return back out here to continue with the state's case in chief. Remember, you are not to talk about this case among yourselves. Thank you, ladies and gentlemen. right, ma'am, if you'll come forward and be sworn. You'll have a seat right there in the center. A little bit different than the usual. If you'll be certain to speak closely and loudly into that microphone.
Okay.
Thank you.
Take your time, get ready. May it please the court.
Yes.
Please the stuff is falling behind you. Please introduce yourself to the two juries.
Yes, hi, good afternoon. My name is Analyst Adana. The first name is spelled Jeannenelyn, and the last name is spelled Adona.
What do you do for a living?
I am a senior crime laboratory analyst at the Florida Department of Law Enforcement, or FDLE.
You had to pause there for how long have you been working there?
It'll be 21 years next month.
Okay. And explain to the jury your educational background, training experience that allows you to come into courts and testify.
Yes, I hold a Bachelor's of Science degree in cell biology and a Master's of Science degree in genetics. And I have successfully undergone a training program at FDLE, which I finished in January of 2010, and I've been conducted independent DNA testing since January of 2010.
And during that period of time, have you undergone training through the Florida Department of Law Enforcement that allows you to come and give your opinion in courts?
Yes.
And approximately how many times have you testified?
I lost count, but I think it's about 87 times.
Okay. And what fields are you testifying in?
I testify in the fields of forensic serology, forensic DNA analysis with expertise on population statistics.
And what is serology?
Serology is the identification of body fluids like blood, semen, and saliva.
And what is DNA testing? Explain that, how it's forensically used.
So DNA stands for deoxyribonucleic acid. It is the genetic material that is passed on from parents to offspring. Half of the DNA comes from the father and half of the DNA comes from the mother. No two individuals would have the same DNA with the exception of identical twins. It is useful in forensic DNA analysis because DNA profiles can be developed from question samples, and these DNA profiles can then be compared to DNA profiles from known individuals.
Is this type of DNA testing well accepted in the scientific community?
Yes, it is.
And have you ever not been allowed to give your opinion on your DNA testing in courts like this?
Never.
Your Honor, I would tender the witness as an expert in DNA testing and its statistical population components.
Any additional voir dire from attorney for Mr. Whitaker? And for Mr. Robinson?
No, Your Honor.
Okay, you may proceed, Mr. Mizrahi.
Thank you, Your Honor. So the jury heard about DNA. We think of DNA as something that defines our biological traits like height, weight, hair color, skin color, eye color. Are those the types of areas of the DNA that you're looking at?
No, the DNA areas that I'm looking at doesn't code for any trait that are visible.
And I think sometimes it's commonly referred to as junk parts of the DNA.
Yes.
Is that because we don't really know exactly what it does?
It doesn't code for anything, so they're, yes, called junk DNA.
But the science is not junk.
It's not.
And it's in the course of your training experience, other than identical twins, do any two people have the same DNA profile?
No.
And the areas of the DNA molecule that we're looking at, are they different among different people?
Yes. So most of our DNA are the same because it codes for our two eyes, nose, ears, and all the other bodily functions. But the areas that I am looking at, they are different among individuals. And that's why we are looking at the small segment of the DNA that are different among individuals.
And during the course of your training experience, do you continue with education that allows you to continue to be up to date on the latest expertise?
Yes, we routinely conduct journal clubs at work, and I also attend DNA conferences once a year.
Does the lab go through the FDLE lab that you work at? Does it go through proficiency and testing to make sure it's accredited, things like that?
Yes,
So, during the course of your testimony today, did you ensure that all the safety protocols of your lab were followed and adhered to?
yes, I did.
So have you had the opportunity to review your 2020 530 file?
Yes,
And if you ever need to refer to it, just let us know. That's perfectly okay, all right? Did you receive a lot of information and evidence related to a Barbara and David Buckley?
I did.
Now, obviously, you're not at the scene collecting all this evidence, so you're relying upon law enforcement to provide you the information on the packages.
Correct.
And then you put in your report what the law enforcement officers have done.
Yes,
You can't testify as to how they did it or anything like that.
correct.
How are you able to testify to this jury that once FDLE gets the item, that item is forensically secure? In other words, you put it into a vault to make sure the seals are done and all that. Explain that to the jury.
So FDLE has an evidence intake section where the items of evidence that are submitted by contributors, the police departments and sheriff's offices are submitted to FDLE. So every case gets assigned a unique FDLE case number, and every item associated with that case gets a unique FDLE item number. Once these pieces of evidence are entered into the system, they are placed in a secure vault that only few members of FDLE personnel are allowed to have access to. And until I request the transfer of custody of those items to myself from the crime laboratory technicians, they remain secure in the vault.
And the jury's kind of, I think, from a distance, seeing things like evidence tape and signatures and things like that. Why is that important?
It is important so that I would be able to know if my seal has been broken into or tampered with after I'm done with my analysis.
Was there any indication in any of your work that the items had been tampered with?
Not with the previous cases that I've testified to where evidence were shown to me.
So I want to go and explain a little bit about what you did there. Lucky for us, the two main items I want you to look at are sitting right to your left. Do you see both a pajama bottom and a pajama shirt?
I see a pajama bottom and, yes, a pajama shirt.
The pajama shirt is 244 and the bottoms are 245. So we're just going to refer to them as bottoms and tops.
Okay.
And you previously looked at those items and identified them as the items that you worked in this case.
Yes.
And I think you could probably see we might as well do it. You can see the bags that are in here that have your identifiable information.
Yes.
So when you're examining items like this, explain to the jury how you go about examining the pajama bottoms and tops to see if there's any DNA that you can test.
So for these particular pieces of evidence, they were described to me as pieces of evidence suspected to contain possible blood stain. So I look for stains that are consistent with originating from possible blood stains, which may present themselves as red-brown staining, brown staining, black staining, green staining, or yellow staining.
And why do you specifically look for blood stains or any kind of stains for doing your DNA testing?
So for this particular case, it was,
Let me ask it like this. Would blood contain DNA?
yes,
Okay.
it will.
So as opposed to going over the whole shirt or the whole bottom searching for potential touch DNA, you go directly to the blood. That's going to give you the best chance.
Yes, and also it was on the case tracking form that possible blood was located on the victim's clothing.
And did you do a test to see if there was any presumptive blood on those items?
I did.
And what was the results of that? If you need to refer to your, go ahead. I'm sorry.
The pajama top and pajama bottoms both gave chemical indications for the presence of blood.
So when that happens, does that target where you're going to do your DNA testing?
Yes, so the same area that gave chemical indications for the presence of blood would be the same areas I will take samples to proceed to DNA testing.
And did you do that?
I did.
Now, before we get into the results of those, it's important that the jury understands the concept of an intimate sample, and what does that mean for your testing? How do you take that into account?
So the items of evidence such as clothing are actually referred to as indigenous samples,
Indigenous, that's better, okay.
and which means that the person wearing the items of evidence, we can expect their DNA to be present and would not be unusual. And I can use that person's DNA sample present on the item to back out their DNA to be able to determine if there's any DNA foreign to that person or any DNA not belonging to that person wearing the pajama top or pajama bottoms.
Did you actually receive a known buckle? I say buckle. Is it buccal or buckle?
I say buccal, but I think most people nowadays say buckle.
Oh, okay. I'm not going to say that. So that's going to be State's Exhibit 219, which is going to be your number 2. Is that going to be Ms. Buckley's known buckle swab?
Yes,
Did you use that to parse out her indigenous DNA from her pajamas?
I did.
So in parsing out Ms. Buckley's, did you also have her husband, or purported to be her husband, David Buckley's buckle swab?
Yes,
And was he excluded as a possible contributor?
he was.
Did you find DNA that was male that was foreign to Ms. Buckley?
I did.
And did you find it on both items?
I did.
So was it a mixture of Miss Buckley and then this unknown person?
Correct.
Just the two of them?
Yes.
Did you also receive Mr. Barner's buckle swab as well as Mr. Whitaker's buckle swab?
I did.
I'll just show you those for the record. The State's Exhibit 222 is going to be Mr. Barner's swab, Dominic Barner, and then State's 224 is going to be Mr. Whitaker's.
Yes.
So when you're getting these known profiles from Mr. Barner and Mr. Whitaker, do you develop a full DNA profile for them?
I did.
Did you compare the full DNA profiles from Mr. Barner and Mr. Whitaker to the unknown male DNA you took from the blood stains on the shirts and the bottoms?
I did.
And let the jury know what the results of that was.
So for the DNA profile from Dominic Barner, his DNA profile was compared to the shirt from Barbara Buckley, and Dominic Barner is included as a possible contributor to the mixed DNA profile obtained from the shirt from Barbara Buckley.
And the shirt would have been number 244 for the record. So included as a possible contributor, what does that mean? Does that mean it could be him, may not? Explain to the jury how statistically significant that is.
Yes, so because I wasn't there and I didn't create the mixture, I can't say it's definitively these people who are in the mixture. So I say possible, but the DNA types are consistent with what I observed between the DNA type from Dominic Barner and the DNA types on the from the top from Barbara Buckley. And then I calculated a likelihood ratio. So the observed mixed DNA profile from the top, from the pajama top, is greater than 700 billion times more likely to occur if the sample originates from Barbara Buckley and Dominic Barner than if it originates from Barbara Buckley and an unrelated individual.
Okay, it says 700 billion is a huge number.
It is.
Is that a conservative estimate?
Yes. The actual number is actually so much greater than that, but we cap our reporting segment at 700 billion because it's something that we are more familiar with. It's a number we're more familiar with.
And even that number is more than any human beings have ever lived on planet Earth.
That I'm not sure, but it's definitely more than the people on the planet now.
Yeah, well, that's fair enough. And the people on the planet now, are we up to 9 billion yet? 10 billion? Are we that high?
I think we just exceeded 8 billion or approaching 8.5 billion.
So this is 700 billion times.
Yes, it's greater than 700 billion.
Greater than 700 billion. So that was with Mr. Barner on the shirt.
Yes, and Dominic Warner is excluded as a contributor to the mixed DNA profile from the bottoms.
Okay, and then likewise, Mr. Whitaker is excluded from the top.
Yes, he is. He is excluded from the top.
We have Barner on the top, and then we have Whitaker on the bottom, which I guess you haven't got to yet. Explain to the jury what the results of the bottoms were.
So a complete DNA profile was obtained from Leroy Whitaker Jr., and that DNA profile was compared to the mixed DNA profiles from the top and bottom. So Leroy Whitaker is excluded as a contributor to the mixed DNA profile from the pajama top. Leroy Whitaker Jr. is included as a possible contributor to the mixed DNA profile obtained from the pajama bottoms. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Barbara Buckley and Leroy Whitaker Jr. than if it originated from Barbara Buckley and an unrelated individual.
And I want to just briefly explain to the jury how you just practically are taking Barbara Buckley out, and then what's the DNA profile left behind? How do you do that?
So, as I mentioned earlier, half of the DNA comes from the father and half of the DNA comes from the mother. And so we have the DNA profile is actually just a pair of numbers at the 21 areas of the DNA that I'm looking at. So individuals will have different DNA types. Only identical twins would have the same DNA. So anything that does not belong to Barbara Buckley is said to be foreign to her.
And in your analysis, were you confident that there was only one other source of DNA, meaning only 2 total contributors?
Yes.
And we should probably show the jury where we're talking about. Did you make marks on the bottoms that indicate where you would have gotten the sample from?
Okay, so on my notes, I said area A is red-brown staining on the back.
Did you do a parentheses and put the letter A there?
Yes.
There's another on the side that's facing me where it says neg.
That is short for negative.
So if the jury, if they need to see it, it's the little parentheses that says
A.
A. It looks like there's a little hole there.
Yes, that's where I collected the sample from for DNA testing.
I also want to show you one other item that you looked at, which is States Exhibit 220220. Do you recognize that?
I do.
What's that?
The neck and left wrist swab of Barbara Buckley.
Again, you would expect to find Barbara Buckley on the swab taken from her neck.
And wrist, yes.
And what were the results of that once you accounted for Ms. Buckley's DNA being present?
So the neck and left wrist swab also gave chemical indications for the presence of blood. And the DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And Barbara Buckley is expected to be a donor to this item, and she is observed in the mixture. David Buckley is excluded as a contributor to the mixed DNA profile.
And was Mr. Barner found to be the other contributor?
Dominic Warner is included as a possible contributor to the swab from the neck and left wrist of Barbara Buckley.
And was the statistic the same? Is that-
Yes, observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originate from Barbara Buckley and Dominic Barner than if it originated from Barbara Buckley and an unrelated individual.
Other than Leroy Whitaker and Dominic Barner, and obviously Mrs. Buckley, Barbara Buckley, did you reveal any other DNA profiles?
I did not obtain any other standards, so I didn't make any other comparisons.
I guess that was not a great question. Was there anything in those samples where you matched it to Whitaker and Barner, like a third person, I guess is the better question?
No.
Is it common in the Florida Department of Law Enforcement for you to develop a full profile of Leroy Whitaker and then, or any defendant or suspect, and then have another analyst use that full profile for comparison purposes on additional testing?
Yes.
And you're aware that that happened in this case?
I'm aware that this is cross-referenced to a different case, to another case, but I don't know if this DNA profile was used for that case.
And you see Ms. Heistler outside?
Yes,
She doesn't live here anymore?
she doesn't.
Was it nice to see her?
Yes.
Okay. And she'll testify about that. But is that common in FDLE for
Yes.
one analyst to do the standard and then another analyst to use that standard?
Yes, I have done that in many other cases.
And the standard that you did for Leroy Whitaker, that's just part of your case file and it gets documented.
Yes,
So someone else can come back and use it.
yes.
That's all the questions I have.
All right, thank you. Cross for Mr. Whitaker.
Good afternoon.
Good afternoon.
How are you doing?
Good, thank you. How are you?
Good. In your 21 years at FDLE, those have all been in serology and DNA?
Yes,
Is it fair to say, over the 21 years, that there have been a lot of changes in the technology?
yes,
And obviously, changes in your protocols as well,
yes,
correct?
correct.
I mean, 20 years ago, did you have the level of safety protocols that are now in place?
I think so. Nothing much has changed with our standard operating procedures, with the exception of the instrument platforms and the amplification kits. But technology is pretty much the same.
Okay. And you mentioned as part of your training, obviously you have your education before you even began at the FDLE, but part of your training at FDLE is to actually learn how to testify effectively,
Correct.
correct?
Yes.
Like you literally have mock moot courts.
Yes.
Okay. All right. Now, you had mentioned something that, to your knowledge, no two people have the same DNA, correct? Besides
Yes.
identical twins.
Correct.
Okay. And that's based on what we know right now, correct?
Yes.
And another way to say that is, and we'll get there, and I apologize for somewhat jumping around, but when we start talking about the statistical significance of a certain result, that's based on a specific database, correct?
Correct.
Okay, and in that database is sample DNA profiles of then where you're able to statistically determine what level of the population might have that particular loci.
This is a likelihood ratio, so I think that's different from random match probability.
I should let you explain it because I guarantee you'll do a better job than me trying to ask the question.
Okay.
What is the database? How was the database created?
So the database is created by collecting samples from blood banks, from, I think for this particular database, it was from Memphis, Tennessee,
Okay.
and Fort Lauderdale, and then there were buccal swabs from Paternity Lab in Ohio. And so these samples were then extracted and DNA profiles were developed and tabulated. And then the number of times a particular DNA type is observed in the population, they are tabulated. And we are using this database, which is used nationwide and used by the FBI as well. And this is published in a peer-reviewed journal, Forensic Science International Genetics, and it can be refuted by other people, other scientists out there, but this has been validated to be valid for our purposes.
For the statistical
For
analysis.
this statistical analysis, yes.
And so, if I understood you correctly, number one, how many people are in the database?
I believe it's about 1,097 individuals in the database, including Asian individuals, which, you know, we're not calculating the likelihood ratio of.
Okay. And a real-world application, is it somewhat the concept? Is it somewhat similar to like when we hear about polling results? And then people are trying to say, because we had a poll result, we can then assume we took a small database, we can now then expand upon what we think will happen for a larger population.
Yes,
Okay, so very similar to like when we'll read in the paper before some type of an election, the polling numbers are suggesting, correct?
yes, but I think it's different in the fact that Caucasian population, the genetic differences between individuals are greater than between populations.
Sure, okay. And so your calculations are, and they're scientific, they've been scientifically validated.
Yes,
But just for kind of the education of our jurors, we're creating these numbers, or we're finding these numbers based on the, I guess, known profiles of, was it 1,197 people?
1,097.
1,097. Okay. Okay. And I think it goes without saying, but I'll go ahead and say it, that obviously those 1,097 samples that make up this database, we know for sure that there were not two DNA profiles that exactly matched, correct?
Correct.
And through all of your 21 years, you have not come across a situation where two different people that were not identical twins had the same DNA profile, correct?
Correct.
Okay. All right. So you had mentioned in regards to kind of the different protocols that are in effect at FDLE that you all actually have your own vault, correct?
We have a central vault in the evidence intake section, and we have our own lockers in the biology DNA section.
Okay. You obviously do not know where a particular piece of evidence or standard was prior to getting to the Florida Department of Law Enforcement.
Correct.
There is a difference between what we call touch DNA, and then I'm going to use the word intimate sample. Would that be correct?
No,
Okay.
not for.
Correct me. Correct me.
Yes.
Tune me
so
up.
intimate samples are samples that were collected from an individual's body, like orifices and, skin swab. And indigenous samples are samples like bedding or clothing or purses or cell phones.
Okay.
But both intimate and indigenous samples, we expect that individual's DNA to be present there. Or we don't necessarily expect, but if we see them there, it's not unusual because they have contact with those pieces of evidence.
Okay. And forgive me, because the distinction I'm actually trying to make by a very poorly worded question is the difference between touch DNA, where you might ultimately be seeking epithelial, versus blood. Okay? And is there a difference?
Yes.
Okay.
Blood is a much richer source of DNA.
Okay. In regards to touch DNA, give us some examples of what touch DNA would be.
So touch DNA would be, if say, for example, my hands are sweaty and then I touch this surface, there is a possibility that I can leave my DNA behind or my skin cells behind on this surface, and then if it's swabbed at a later time, then my DNA can be picked up from those skin cells, but it's not a guarantee. There's a lot of factors that come into play with touch DNA, getting left behind on an item or not.
And sometimes you will know that you have DNA, but you don't have any identifiable DNA or interpretable DNA, correct?
Can you repeat the question?
Sure. And let me actually go to the example in this particular case. Just for an example of sometimes you know there's DNA there, but it's just not interpretable. In this particular case, you attempted to get DNA from Miss Buckley's fingernail swabs.
Correct.
Okay. And your ultimate result in regards to that was due to the limited nature of these results, the data is not interpretable.
Correct.
Okay. You did find, though, that there was DNA foreign to Miss Buckley, correct?
Correct.
Just,
It was too little to be compared to anyone's standard.
and you also have that with the instrumentation, that there are times you're ultimately, to get these numbers, you're looking at graphs.
Yes.
You're looking at peaks.
Correct.
And if a peak isn't, there's sometimes what you call, you can't call a certain peak, correct?
Yes.
Help us understand what that phrase means.
So we have a threshold. So a peak has to reach a certain height in order for me to be able to say that that is a DNA peak attributable to a person.
And so there are times that we have what's called a mixture, correct?
Yes.
Okay. And what I've heard you explain is that, or actually let me start with the results in regards to the pajama bottoms.
Yes.
Would you call that a mixture?
It was a mixture.
Okay. And is it fair to say you call it a mixture because you found at least two different persons' DNA?
Correct.
Okay. Mr. Mizrahi had asked you a question, were you confident, and we're specifically talking about the pajama bottoms, that it was only the two, that it was only two people?
With the results that I interpreted and I have observed, I am confident it is only two and two individuals only.
Okay. But again, we unfortunately have in DNA technology situations where you may have peaks that don't meet your threshold, correct?
Yes, but I don't interpret those peaks because they're not interpretable.
Sure. And so they're not interpretable in terms of identifying them to anything, correct?
If they're not even called, I can't interpret them.
Okay, you can't even call it a specific DNA marker.
Correct.
Okay, fair enough. There are a number of steps in regards to the DNA process, are there not?
Yes, there are.
You actually do not complete all of those steps yourself, do you?
I don't.
And in this particular case, there was an Aliyah Field, correct? Am I pronouncing her name correctly?
Aliyah Fields.
Aliyah, is it Fields?
Fields,
Okay.
yes.
She's no longer with the Florida Department of Law Enforcement?
She's not.
Okay, but she performed some of the manual steps in this process, correct?
Robotic steps.
Okay. She also helped perform the quantitation setup?
Yes.
Okay. And then there was another worker, Roe McKenzie?
Rowena McKenzie, yes.
Okay. And she also operated the robot for amplification?
Yes.
Okay. And you're a supervisor at the Florida Department of Law Enforcement, correct?
I am.
Within your
I am not.
You are not?
I am not.
But you were supervising these people, correct?
I'm not.
Okay. But they do important steps to the DNA
Yes.
process, correct?
They have undergone training and they have completed their training successfully. They do proficiency testing and competency testing before they are able to operate these instruments with casework samples.
In your time at the Florida Department of Law Enforcement, you have experienced instances of what's called sample carryover contamination, correct?
Yes.
Okay. If you could, explain what that is to the jurors.
So sample carryover contamination could occur if there is a sample that has a large amount of DNA that could then bleed over to other samples that are adjacent to it on a plate.
And you personally, ma'am, are not sure of how many times in your career at FDLE you've had instances of contamination?
I don't remember, but it is recorded.
There is documentation as is required for
Yes.
your accreditation. Can I just have one moment, Your Honor?
Yes.
When you were asked, ma'am, in regards to whether or not other analysts, and I think you mentioned that you were aware in this case that there might have been two separate analysts working on different aspects or different parts of the case. What would that analyst use in terms of what you produced for the known profile of Mr. Whitaker?
The DNA profile that was generated in the course of the analysis.
Meaning the double numbers
Yes,
or the actual item?
just the double numbers.
And can I approach the witness, ma'am?
Yes.
Showing you the pajama bottoms, which reads 10L for identification, but I think it's been introduced. And I just want to make sure that I understand. Where this is marked A, this is where you took the actual cutting,
Correct. That whole.
that hole. What is the significance of what's on the back?
That is actually the front.
Oh, I'm sorry, the front.
So there is a stain there that I think could be a possible blood stain, and I tested it presumptively for blood, and it was negative. So I marked it.
And that's why you stopped any further analysis?
Correct.
Okay, how about this other where it says maybe NEG?
No, that was the negative.
Oh, I'm sorry, I see another mark then.
Oh. That must have been negative, because I only assigned a alphabetical identifier on areas that gave chemical indications for the presence of blood. I must not have labeled that negative.
Okay. Can you look through your bench notes? Because obviously you take very detailed
Right.
notes over exactly what you do.
So I said with red-brown staining on the front pant leg and back pant leg, and positive area A, right, red-brown staining on the back, and negative red-brown staining on the front. And a sample was collected from area A for DNA analysis.
Okay. All right, thank you very much, ma'am. I don't have anything further.
All right, thank you. Cross for Mr. Robinson.
Please, Your Honor. Good afternoon.
Good afternoon.
I didn't have anything for you, but then you were talking about population, so it caused me to put together a few questions. So you were asked about 700 billion times more likely, right?
It's actually greater than 700 billion times.
That's a lot of billions.
Yes,
And we all agree, and I think that it was Mr. Mizrahi that said that that's more people than have ever been on the planet.
which I'm not sure of.
Okay. But it's more than are on here right now. I'll agree with that.
Yes,
Now, if instead I were to change it, and this doesn't have to do with your analysis, but your expertise, if I were to change that to 4.4 million times more likely, that's a lot less, right?
yes.
Is that equivalent to the population of Florida?
See, the likelihood ratio statistic that I calculate doesn't have anything to do with the Earth's population. It is independent of it. But the fact of the matter that we are capping the reporting at 700 billion is because it's something that most people can relate to.
Okay, but we're talking about 4.4 million.
I don't know
Let
the,
me finish
okay.
the question. If it's 4.4 million, and I understand that you're going you're not saying that it's against the population, but the terminology that's used by FDLE, that's used by all analysts across all reports, ties to the population, correct?
It doesn't.
So then what's the relevance of the number? To just give a big number?
No, the likelihood ratio is what the number that is the statistics that is calculated when comparisons are made.
Okay. So you can have, and we can end with this. You can have comparisons when it's in the hundreds of billions, right?
Yes.
If it's on the low end of the millions, that's lower, much lower on the spectrum, right?
Yes.
Nothing further, Your Honor. Thank you.
Okay, is there any redirect?
So Ms. Schlacks briefly brought up the concept of not having DNA and the fragility of DNA. Could you explain to the jury, in your training experience, if I touch something, does that mean I'm going to automatically leave behind DNA that we're going to find?
No.
Explain that to the jury.
So, as I've mentioned earlier, there's a lot of factors that come into play as to when touch DNA can be left behind. It depends on the length of time between the contact of the skin surface and the item of evidence. It depends on if there was enough friction to slop off skin cells from the skin surface to the item. It also depends if the person recently washed hands, or if the item was clean prior to it being swabbed or being sampled after it was touched.
What about environmental factors? Heat, water, stuff like that.
DNA is a very stable molecule. However, it can be degraded by extreme heat. It can be degraded by cleaning products. It can be degraded by water because it can promote microbial growth. And it's also sensitive to pH changes.
It can also be like wiped away.
Yes.
I just want to make sure it's not necessarily cleaning products, but just wiping something away.
Yes. Somebody could have touched it, and that person just like picked up the DNA with his skin surface or her skin surface, and DNA was not there anymore.
Ms. Schlacks asked you about the why about there being only two contributors to the DNA? Why are you so confident that it's only two?
Because like I mentioned earlier, half the DNA comes from the father and half the DNA comes from the mother. It can be the same DNA type at one area of the DNA, or it could be two. The maximum number of DNA types that I expect at one area of the DNA for one person is two. So anytime I see 3 or 4, then it tells me that there's more than one individual there. And the DNA that I observe on the shirt, or the bottom and the top, I am very confident that there are just 2 people because I've seen a maximum of 4 DNA peaks.
Never saw a 5th, which would indicate a 3rd contributor.
Correct.
And the DNA profile that wasn't Barbara Buckley matched the DNA profile of either Barner or Whitaker.
They align with their DNA profile. They're consistent.
And we're looking at 21 different locations?
Correct.
Explain to the jury, because we excluded Mr. Buckley. If there's any location where that DNA does not match either Mr. Barner or Mr. Whitaker, are you able to definitively exclude them as being a contributor?
Exclusion is absolute. If there's any discrepancy whatsoever in just one area of the DNA, that is on exclusion.
And we were talking about the population of the Earth, but this statistical probability is to show how rare the likelihood of someone, an unknown individual, contributing that DNA versus either Mr. Barner or Mr. Whitaker. Is that a better way to say it?
It sounds correct, but I don't know if it is correct.
Well, it's not. You're not saying that there's a 700 billion people in the Earth, and you might find one person that has that.
No. What I'm saying that DNA profile is 700 billion times more likely to occur if it originated from Barbara Buckley and Dominic Barner on the pajama top than if it originated from Barbara Buckley and an unrelated individual who is not Dominic Barner. So The likelihood ratio is a statistical calculation that compares two opposing explanations to the same event. So the event being a mixed DNA profile of two individuals was observed on the pajama top. The first explanation is that DNA profile originated from Barbara Buckley and Dominic Barner. And the second explanation is that DNA profile originated from Barbara Buckley and an unknown individual. The first explanation is greater than 700 billion times more likely than the other explanation. That is what likelihood ratio is about.
And I assume you're not an expert in political polling or anything like that. Is that true?
I'm not.
But in your lay mind, have you ever heard of someone being 700 billion times more likely to win than somebody else? Have you ever heard that kind of polling reported?
No.
That's all the questions I have, Your Honor.
All right, thank you. May this witness be excused? All right, thank you, ma'am. You're excused and free to go.
Thank you.
All right, State, you may call your next witness.
Oral Heistler. We can get them. Oh, go ahead, yeah.
Yes. All right, ma'am, if you'll come forward and be sworn. All right, if you can have a seat right there in the center. And be sure to hold that microphone or have it close to your mouth. Speak loudly and clearly. Thank you, ma'am.
Hey, please, the court.
Yes.
Please introduce yourself to both juries.
Hello. Hello. My name's Coral Heistler. It's Heisler.
What do you currently do for a living?
I work at the Charleston Police Department, and I just opened up a new forensic DNA laboratory.
Is that working at the Charleston Police Department you opened up?
Yes.
So you, that's kind of cool. How long have you been there?
About a year.
And so you moved from Jacksonville, Florida?
Yes.
And were you previously employed with the Florida Department of Law Enforcement?
Yes, I was.
For how long were you employed with Florida Department of Law Enforcement?
For about 14 years.
And the jury's already heard about who FDLE is, and were you a DNA analyst?
Yes, I was.
You currently still are in Charleston.
Yes.
So explain for the jury a little bit. We've already heard some of it about your educational background, training experience that allows you to come into courts and testify.
I have a bachelor's from Penn State in forensic science with the option in biology. I was trained at FDLE through a two-phase training program. The first phase is mainly academic. There are readings, textbooks, exams, lab practicals. And the second phase is supervised casework, where I'll work actual cases under the supervision of a qualified analyst. There's a series of 3 oral boards or oral examinations in front of my training committee and a mock trial.
And over the years, have you undergone proficiency testing to make sure that you're qualified to testify in DNA?
Yes, I have.
And is the lab accredited?
Yes.
And the jury's heard a little bit about this. When you're doing specific testing, do you make sure that the samples that you're testing both are not tampered with, and that you're doing your testing without tampering with it externally from like you or other analysts?
Yes, I make sure the package is sealed, and I wear protective equipment, PPE, like a mask, gloves, hairnet when I work the items.
When you actually work the items, do you use blanks to make sure that there is no contamination?
Yes, I do.
So have you, and how many times have you testified as an expert?
About 70 times.
You ever not been qualified and expert in forensic DNA technology and the statistical components?
No.
At this time, I would tender the witness.
Any voir dire from Defendant Whitaker? And from Defendant Robinson? All right, you may proceed.
So the jury has already heard of deoxyribonucleic acid and how it's worked forensically, so we don't need to go all through that. Have you had the opportunity to review your case file with regard to 2020-626?
Yes.
It's pretty lengthy.
Yes.
Nick, okay.
It is.
You did a lot of testing in this case?
I did.
And we heard from Analyst Adana, who indicated that she did the sample from Leroy Whitaker. Did you eventually use her produced sample in some of your comparisons?
Yes, I did.
Is that commonly done at the Florida Department of Law Enforcement?
Yes.
And throughout DNA technology, because you're in Charleston, yeah?
Yes.
So I want to turn to your testing, and we'll kind of go through with it. The items taken from reported to be a Nissan sedan. Did you do DNA testing on 2 white shirts from the Nissan sedan?
I did. May I refer to my notes?
If that helps refresh your memory, you may.
Thank you for asking. I should have said that. I said it to the other one.
Yes, I did.
Did you also do swabs from the rifle and the Glock?
Yes, I did.
Did you also swab live rounds and bullet fragments?
Yes.
So we'll go through some of the easy things first. The bullet fragment, did that end up matching Charles McCormick? The victim in this case.
Yes.
Okay, so the swab from the live round, that did not demonstrate anything that could be extracted and quantified?
The steps, I do extract the DNA, and when I moved to the quantification step, there was insufficient DNA to continue the DNA process.
Okay. And so those were the swabs from the live rounds in the rifle. Also, were there swabs from the rifle and the Glock? Did those indicate a mixture that could not be interpreted?
That's correct.
So that was the easy stuff. Let's go, and it's actually right to your left. I know you previously looked at them in your pre-trials. These are the 2 shirts, beginning first with State's Exhibit 210, which corresponds to Exhibit number 9 for you. Right?
Yes.
And then State's 211, which reports to Exhibit number 10.
Yes.
And where was 9 located according to the law enforcement, and where was 10 located according to law enforcement?
Nine was the driver's seat, and 10 was the rear seat middle.
Okay, so I'm going to refer to 9 as the driver's seat, which 9 is going to be 210, and then 211 will be 10, the rear seat. Okay?
Okay.
So we'll just do front seat, back, driver's seat, back seat. In the analysis of the white T-shirt, were you able to locate a hair that could be tested for DNA?
Yes.
Objection, Your Honor, just clarification, which white T-shirt is this to?
Yeah.
From the driver's seat.
Yes.
Explain for the jury how you determine that a hair is suitable for DNA testing.
I take the hair, I put it under the microscope, and if I see possible debris or epithelial cells or look at the root and determine it's suitable for DNA testing, I proceed. I take a cutting of the end of the hair and put it in a tube.
And did you determine that that DNA was from a single source?
Yes.
And did that DNA end up not matching some of the people we're going to talk about that we've already heard, Leroy Whitaker, Hakeem Robinson? It did not match any of those people.
That's correct. They were excluded.
All excluded.
Yes.
Okay. But did you also perform a test on the shirt itself?
Yes, I did.
How did you go about doing that?
I swabbed specific areas of the shirt to look for wear DNA, and I swabbed the collar area and the armpits, and I believe the shoulders. 1 second.
You can check to see. And you're using one swab for all of those areas?
Yes, to concentrate the DNA on one swab. I swabbed the inside of the shirt, collar, armpits, and shoulder.
And in doing that test, did you determine that there was a mixture of DNA that could be compared to other people?
Yes.
And that mixture was consistent with how many individuals?
3 donors.
Were you able to exclude in your first round Charles McCormick, Krista Odom, Cora McKnight, and Miss Barton? I don't want to say her name wrong. Eva Barton were all excluded as possible contributors?
Sorry, I have them listed as numbers. I just have to verify.
Okay. Yeah, take your time.
Yes, they were excluded.
Were you later provided the known DNA samples from a Leroy Whitaker and Hakeem Robinson?
Yes.
And did you compare those known DNA samples to the mixtures in the driver's seat T-shirt as well as the rear seat T-shirt?
Yes, I did.
And what results did you have beginning first with the driver's seat T-shirt?
For the driver's seat, Leroy Whitaker is included as a possible contributor to the mixed DNA profile obtained from the item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker and 2 unrelated individuals than from 3 unrelated individuals.
And the jury has already been explaining that billion-time likelihood, but I guess let's just get a different perspective. What does that mean?
Its likelihood ratio is a weight of the evidence in a form of a number. I can tell you, yeah, it's 7 billion times more likely or 700 billion times more likely, but that doesn't really mean much. Like if I can say he's included, but that doesn't mean much without giving you a weight to the number. And that 700 billion is the weight.
And to confirm the Hakeem Robinson, did you actually perform the DNA analysis on his known buccal swab?
Yes.
And that's going to be states 223?
Yes. Buckle.
So 700 billion times Hakeem Robinson on the driver's seat, but there's a mixture of multiple people.
It was a mixture of 3.
Turning to the rear seat, did you perform the similar DNA analysis?
Yes, I did.
And what were the results of that?
That also demonstrated a mixture consistent with 3 donors.
And did it match any known profiles that the Florida Department of Law Enforcement had developed?
Since it's not a single source, I don't say match, I say included. And Leroy Whitaker is included as a possible contributor to the mixed DNA profile obtained from this item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker and 2 unrelated individuals than from 3 unrelated individuals.
And so same testimony that you gave with Mr. Robinson in terms of what that means, 700 billion, what it means.
Yes. I stated the inclusion for Leroy Whitaker for item 9 and 10. We didn't go over Mr. Robinson for item 9.
Who'd you say for item 9? I'm sorry. I missed that.
I just stated the inclusion for Leroy Whitaker for item 9 and 10, not the other individual yet.
Correct. I'm sorry. Let's go back to 9 so I make it clear. Who's on 9? Or who's included on 9? 9 being the driver's seat.
I did state Leroy Whitaker was included as a possible contributor, and that's the likelihood ratio of 700 billion that I gave. And when I compare Hakeem Robinson, I do also include him as a possible contributor to the mixed DNA profile, and it is the same likelihood ratio. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Hakeem Robinson and 2 unrelated individuals than from 3 unrelated individuals.
Sorry, I wasn't listening carefully. So both Hakeem and Leroy Whitaker are included on the driver's.
They are.
Objection, mischaracterization of the testimony.
Well, let's have the witness clarify. T-shirt on the driver's seat. Tell me, repeat again, if you will, please, who is included in that T-shirt?
I independently looked at the reference samples from both Leroy Whitaker and Hakeem Robinson. In my first statement, I compare Mr. Whitaker, and I'm including him into the mixed DNA profile that originated from item 9, or the driver's seat white T-shirt. And then I look at Hakeem Robinson, and I also included him as a possible contributor to the mixed DNA profile. And then I reported the likelihood ratios independently for each of them.
So we heard from Analyst Adana that she's confident in one of her other, and it has nothing to do with what you did, that she knows it's only 2 people because there's no more than 4 loci at any particular location on the DNA, no more than 4 alleles at any particular loci. So here, are you confident that there's at least 3 people involved?
Yes.
How can 2 people both Case Exhibit 226 and State Exhibit 225, which are samples that you developed of Abdul Robinson Jr. and Abdul Robinson Sr.
Yes.
And were you able to exclude Abdul Robinson Jr.?
Yes.
And with Abdul Robinson Sr., were you able to exclude him in some areas, and then it was undetermined in others?
From the driver's side?
I'm sorry, for the shirt, he was excluded. Go ahead. Just explain the results. Let me stop looking at.
For item 9, the T-shirt from the driver's seat?
Yes.
They were both excluded.
I was talking about the driver's compartment where
Okay.
I'm jumping ahead. It's my fault. And they were excluded from the rear middle seat as well.
The T-shirt on the rear middle seat, they were also excluded from.
Okay, and I don't think we've given the results for the rear yet. What were the results on the rear?
We have not.
Let's do it.
Okay. So what results are you looking at now?
DNA mixed, 3-person mixed DNA profile from the T-shirt from the rear of the vehicle, the rear seat. Number 10, I believe.
They are also excluded from that.
But were you able to include, and also Hakeem Robinson was also excluded from that?
Hakeem Robinson is excluded as a contributor to the mixed DNA profile obtained from the white T-shirt from the rear middle seat.
You were able to include Leroy Whitaker to that shirt?
Yes, he is included as a possible contributor to the mixed DNA profile obtained from this item. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Leroy Whitaker, and 2 unrelated individuals than from 3 unrelated individuals.
Okay, so despite my jumping around too much, Hakeem Robinson and Leroy Whitaker are included on the front seat and only Leroy Whitaker on the back seat.
Objection, mischaracterization for testimony, front seat versus T-shirt on front seat.
Okay, if you'll just clarify your question.
T-shirt that we've talked about that's sitting right to your left side,
Yes,
that mixed DNA profile included both Hakeem Robinson and Leroy Whitaker.
yes,
And the rear seat T-shirt sitting right to your left, it was just Leroy Whitaker.
correct.
So did you also get some touch DNA swabs that were taken from the reported 4 compartments of the Nissan car, sedan?
Yes,
And 3 of them, were you able to report any identifiable DNA?
no, it was a mixture that was not suitable for comparison on 3 of the items.
Were you able to report some information with regard to the driver's seat compartment swab taken from the Nissan sedan?
Yes, it was a mixture consistent with 4 donors.
That's 4, so that's the most we've seen. Is that to be Stacy's Exhibit 221?
Yes,
So Stacy's Exhibit 221 had a mixture of 4 potential donors.
that's correct.
And what did you report in terms of Hakeem Robinson being a contributor to one of those profiles?
He is included as a possible contributor to the mixed DNA profile, and the observed mixed DNA profile is approximately 4.4 million times more likely to occur if the sample originated from Hakeem Robinson and 3 unrelated individuals than from 4 unrelated individuals.
So explain to the jury why we see a number like 4.4 million as opposed to 700 billion.
I'm looking at the frequency of the DNA types and the overall profile and making that comparison. So it's not quite as big as 700 billion, but it is an inclusion that's greater than 1 or whatever number you would say. I'm just giving a weight to the inclusion.
And is the number potentially explanation for it because there's so many contributors of DNA because there's 4 potential people? Or is it because you just didn't have as much DNA to analyze?
It's just looking at the overall profile and how I can include him at certain locations and the frequency of the alleles at those locations.
Were you able to exclude people from that driver's side swab?
Yes.
Who were you able to exclude?
Leroy Whitaker is excluded as a contributor to the mixed DNA profile obtained from that item.
And how about Abdul Robinson Sr. and Jr.?
They're 35. Junior is excluded and 34, or I'm sorry, senior is inconclusive. I couldn't make a determination to include or exclude.
The junior was excluded.
Yes.
All right. May I have a member to check with counsel?
Yes.
Thank you, Your Honor. That's all the questions I have.
All right, cross for Mr. Whitaker.
Good afternoon.
Good afternoon.
How are you doing?
I'm good. How are you?
Good, thanks. It's somewhat obvious, but just to get it out there, you can't see DNA, can you?
I mean, I can see red-brown staining if there's blood, but I can't see the DNA profile, no.
Sure. And like when you look at any item, and what I'm trying to have you explain for the jurors is just how tiny DNA is.
Yes, it's very small.
I've heard it referred to that you can't even, you can fit, correct me if I'm wrong, like a million DNA on the top of a pen.
head?
I haven't tested that.
But it's fair to say it's extremely small, correct?
Yes.
Okay. And you never know, with the exception of if you see some red-brown staining, you can anticipate you may very well have a DNA result if it is in fact blood, correct?
Blood is a rich source of DNA.
Sure. But sometimes a stain can be some other substance that's not blood, correct?
Correct.
And so there's no way you, as the analyst, when you look at any of these items, have any idea what DNA results, if any, you might get, correct?
When I look at items, I'm trained in identifying stains, so I do look for specific stains that would have characteristics of blood, if that's what you're referring to. But I don't know if it's going to be a mixture when I'm swabbing something for wear or single source, or maybe no results even.
And so let's go specifically to, I guess we have some T-shirts that you ended up analyzing, correct?
Yes.
And my understanding, and please correct me if I'm wrong, is that you did not take cuttings. You literally made your own swab. Is that correct?
Yes, I swabbed the shirts in those areas.
And it sounds like one of the reasons you would have swabbed the particular areas that you did is that you're trying to capture maybe known areas where people naturally sweat. Would that be fair?
Not necessarily sweat, just I know that has the most contact with their body, so it would have skin cells on it to identify who was wearing the shirts.
And so you look for those particular areas because you're trying to capture whatever DNA might be there, correct?
Yes.
And when we're talking about trying to get DNA from an item such as the two shirts that are next to you, DNA technology can tell us a lot, but it can't tell us when that DNA got on that shirt, correct?
That's correct.
And can't tell us how it got there, correct?
That's correct.
Because there is this concept of transfer of DNA, correct?
Yes, there's transfer DNA.
And I'm sure as part of your very extensive training, you've become aware of studies that they have done, scientific studies, where if I grab this pen and then hand it to Mr. DeCoste, and then you test the DNA from Mr. DeCoste's possession, my DNA may very well be on that pen, correct?
Yes, it's possible. That's more so like touch DNA versus wear DNA.
Sure. But the concept exists, correct?
Yes.
And that's something you just always have to be aware of when you're doing your analysis and trying to explain the results, correct?
It doesn't really affect my analysis on the DNA because I'm still just testing what DNA is on the shirt. I don't know how it got there.
Nor do you know when, correct? Because DNA can be degraded over time, but I think we're all aware of situations where DNA has been recovered 10, 20, 30 years down the road.
Yes, that's why we do cold cases.
And so that technology exists as well.
Yes, it's the same DNA technology that I'm using.
In this particular case, you were never given a standard of Dominique Barner?
That's correct.
So you did not include or exclude him from any analysis you completed?
I made no comparisons of that person.
How about anyone named Chris Brown?
No.
Okay. How about anyone named Torrigan Williams?
No.
Did you do any testing on any hairs found?
Yes.
Okay. And what kind of testing on hair does FDLE do?
It's the same DNA testing.
There's also something called mitochondrial DNA testing, correct?
Yes, there is.
Okay. Florida Department of Law Enforcement does not do that testing, correct?
But they do not.
And so that was not completed in this case?
No.
Okay. And mitochondrial DNA testing is for the Y chromosome? Is that correct?
That's for Y DNA testing.
Okay.
For mitochondrial DNA, it's looking at the whole hair shaft, and I only look at the root end of the hair when I do perform DNA analysis. I do STR, which stands for short tandem repeat DNA testing.
And in this particular case, I guess there were about 70 hairs?
On what item?
I'm sorry?
On which item?
I guess total on all the different items that you were looking at?
I'm notated on item 9, which is the shirt from the driver's seat, that I collected approximately 70 apparent hairs, and that there was a clump of apparent hairs and some also remained on the shirt. And on the other white t-shirt from the rear, that had about 65 hairs, and some also remained on the shirt.
And then you ended up picking 2 out of those hairs for DNA testing?
I determined 2 to be suitable to continue DNA testing with.
Okay. I don't have anything further. Thank you very much, ma'am.
All right, cross from Mr. Robinson.
I could have one moment?
Okay.
Can I use this? Great. No, not yet. I'm going to come over with him. All right, thank you. Good evening. Hi.
Yes.
How are you?
I'm well. How are you?
Doing well. Your Honor, I'm going to approach. I want to retrieve Exhibit 210.
Okay.
Mr. Robinson's DNA is not involved in that one. Do you understand this to be your item 9, Exhibit 210?
Yes.
Put her over here in front of the jury. Safe to say, when you get that, it was a dirty article of clothing?
I actually notated it was not very dirty.
Look, I have a dog, I have hairs all over my clothes, but there was a lot of human hair on that t-shirt, right?
I can't testify if it's human hair. I noted there were hairs.
There was also multiple types of DNA, right?
When you say types, do you mean like blood, semen, saliva, or different people?
Tell me.
I don't know what you mean.
Let's leave it at this. It was not a freshly laundered shirt.
I don't know when it was laundered.
Freshly laundered meaning that it's clean, it's folded, like the shirt that I put on today before coming here. Do you have any indication that that was a clean, freshly laundered shirt?
I don't.
Okay. So you get the shirt, what I will term is the dirty shirt, and you tested it. You pulled off a bunch of hairs and you found how many were suitable?
2.
So that would have left 68 hairs that were on that shirt, give or take.
Those are the ones I collected. There were possibly more, yes.
Now, with respect to private lab testing, mitochondrial DNA testing, the remaining 68 on that could have been tested, right?
I should clarify, I wrote they're apparent hairs. I'm not saying they are definitely hairs. So I don't know if they could have been tested.
Fair enough.
If they're fibers, that wouldn't have DNA necessarily.
Fair enough. But there were, the hairs that you determine are suitable for testing, they have the root. And that's what you can test, right?
Yes, I look at the root.
All right. So however many other hairs there were, if it were 2 or if it were 68, those could have been tested because these private labs can test the actual hair, right?
Again, I'm not saying necessarily that they're hairs or human hairs or fibers. I'm just looking at items that were not suitable for DNA.
You testified a moment ago that there was a clump of hairs.
I did say a clump, and I should have said apparent hairs. I didn't pull them all apart.
But if we don't look, and we don't know, right?
I wasn't able to pull them all apart, and I'm not able to say if they are fibers or hairs. I'm sorry, I'm not trying to be confusing, but it was a clump that was all intertwined. There could have been fibers involved in them. I'm not specifying the difference between, if that went to a trace DNA or a trace section instead of DNA.
You found 2 hairs that were suitable, but you would agree that there was other hairs recovered from the shirt. Understanding that some of them may have been fibers, there was other hairs that were recovered
Yes,
that could have been tested
yes.
if the state chose to send them for mitochondrial testing, right?
I'd imagine, I'm not sure how that works.
Okay. Now, you got another name from the hairs, right? Tied back to a gentleman, Mr. Hogan.
Objection, Your Honor. Hearsay.
All right, sustained.
Without saying the name, you tied one of the hairs back to somebody whose name has not been said in this courtroom, right?
I'm not sure how to answer that.
We need to reject, we might need a reproach.
Okay, let me see court reporter and counsel at sidebar.
Yes.
But not necessarily. He could have wiped his brow with it, right?
Yes, I don't know how the DNA got on the shirt.
Nor do you know when it got onto the shirt.
That's correct.
All right. If it's 700 billion and it degrades down, you can't put sort of a time on it, like the rings on a tree, right?
So that's not really how it works. It doesn't degrade from 700 billion. That's the likelihood ratio I'm associating with comparing the two. Degraded DNA would be, let's say, a good DNA profile with information at all locations that then was subjected to, let's say, extreme heat, and it degraded and gave a different type of effect to the DNA that made it less likely for have DNA at every location tested.
So we agree. You can't say when the DNA got onto the shirt.
That's correct.
And the fact that his DNA is on the shirt that's in the car, that doesn't mean he was ever inside of the car, right?
No, I'm just testifying to the DNA. I don't know how it got there or when the shirt got there or who was in the car.
Now let's talk about the driver compartment, okay?
Okay.
Now, you never go out to the car. You get the swab from the different compartments, right?
Yes.
I'm showing you it's been entered in as States 88. Always takes a minute. All right, does that look, I don't know if that's upside down or not. Can you see the steering wheel off to the left and then the rear, the different gears, the gear shifter?
Yes.
Okay. Do you agree that looks like a T-shirt from the front seat?
Yes.
Now let's talk about an example. Ms. Schlack used me for one a moment ago, all right? I'm wearing this jacket, a little bit chilly in here, got a little bit heated this morning, but I want to be a gentleman to Ms. Schlack, so I give her my jacket. I never sit in her seat, I never sit at her desk, right, but I give her my jacket. She puts it on, she wears it, leaves for the day, I get it back, right? If a tech were to come in here and swab that seat, that desk, my DNA could be on that seat, right?
I have no idea I'm not making the connection from you wearing.
This jacket that I'm wearing right now, right? This morning, it got a little tough. Maybe a little bit of sweat in here. My DNA is in this jacket, right?
She sits it on the desk.
Just stay with me step by step. My DNA is on the jacket, right?
I don't know. I haven't tested the jacket.
It could be.
Yes.
Like that T-shirt on it, right?
Yes.
Now, I want to be a gentleman, and I give my jacket to Ms. Schlack. I don't sit in the chair. I don't go near their table. I got my own. But I give her my jacket, right? She puts it on. It's on the chair. My DNA, we agree, is already on it. My DNA is going to end up, it's going to transfer over to that chair. That's how DNA works, right?
I wouldn't say that. The inside of your jacket is where you're assuming that I'm saying the DNA is at, or the outside. I'm not. I haven't tested the chair or your jacket to say that there's DNA on it.
Why don't we make it easier than a jacket? All right, my client's hanky, right? I use it. Hands are a little sweaty, nervous, right? And I want to be a gentleman again, and Ms. Schlack's, here you go to be able to use it, right? So my DNA, I wipe my nose, sorry. My sweat's on it. My DNA is on this. I'm telling you my DNA is on it, and I give it to Ms. Schlack's. Now, when she's here, she puts it on the table, and at the end of the day, she figures she leaves it on the chair. My DNA has made its way over to that table without me ever being at that table, right?
Okay.
It's possible.
Yes.
That is a thing that you have the transfer of DNA.
So are you saying the DNA is now on the table?
I'm saying that my DNA very well, in actuality, because I just touched it, my DNA very well could be on that table right now.
It's possible. It all depends on the friction, the length of time. If I'm pressing hard on something to leave my DNA on the item versus just gently tapping on an item, if it's just sitting on a table, it's not going to necessarily jump off the handkerchief onto the table. But if you apply pressure to it, then it's more likely to transfer the DNA from one item to another.
All right, now this T-shirt, you didn't get back 700 billion times. You got back 4.4 million, right? That's much lower.
You're not phrasing it the way that I did, and
Well, tell
I'm
me how you
making
phrase it.
comparisons. So I'm not saying the shirt has 4.4 million.
No. I want to make sure that we're clear because we're not talking about necessarily the shirt. Right now, we're talking about the swab of the compartment, right? So let me back up for the example. This may help out. The swab is done by one of the evidence techs here in Jacksonville and then sent to you, right?
Yes.
So they go in there, and in this example, right, I'm the tech, and I got my swab, and I go out here, and I have one swab for the front compartment. Now, this handkerchief, it's there in the front compartment. I'm swabbing. I move that out of the way. I'm swabbing here, I'm swabbing here, I'm swabbing the front, and I'm getting DNA. What I'm talking about is the fact that that T-shirt had his DNA on it. You can't rule out that the DNA transferred to the compartment, and that's why it comes back. You can't rule that out, can you?
No, I don't know how the DNA was on the compartment.
It very well could have been because there was a T-shirt that had his DNA all over it sitting in the front compartment.
I don't know how his DNA got on the compartment.
All right. So for the example that we use, that hanky, but now I've been over there, but that hanky, because I touched it, my DNA was on it. My DNA is now on the table, on the chair. It can transfer that way through an article of clothing.
Just because you touch it doesn't mean your DNA is on it.
But it could get on there.
Yes.
Okay. So, sum this up. This T-shirt has my client's DNA on it, right? Right?
I included him into a mixture.
All right, so you believe his DNA is on it.
Yes.
That T-shirt is rolled up in the front compartment, right?
Yes.
One swab is used for the entire front compartment.
Let me see.
When I say the front driver compartment.
And you're saying how many swabs they used?
Well, you already told us one swab.
I said I used one swab to swab the T-shirt.
No. The front compartment of the vehicle, you didn't swab it. It was given to you. How many swabs were used in the front compartment, if you know?
I can look. I didn't already tell you.
Okay,
that.
sure, please.
There was one swab that was used.
All right. So you got one swab. The T-shirt's gone. They're swabbing the front compartment. You can't rule out the possibility that the reason why the DNA is showing up in a mixture in the driver compartment wasn't because it came off that shirt.
I don't know how the DNA was deposited on the driver's compartment.
My question to you is, you can't rule out that it didn't come from that shirt.
No, I don't know how it was there.
So with all of your testimony here, you have no way of saying that Hakeem Robinson was ever inside of that vehicle.
No, I don't know that.
And the last question is the mixture that you, no further questions, Your Honor, I'm good.
All right, thank you. Is there any redirect?
Ms. Heistler, there was some discuss about all the hairs, and I want to have you explain a common misconception to the jury, because they may see crime shows where crime analysts are able to provide DNA results after a commercial break. Is that the way it works?
No, it's not. I did look at the hairs under the microscope, and When I determine the suitability, I determine if they're suitable for DNA. I don't notate why they are not suitable. It could not be suitable because there was no root or because it's not a hair. I don't notate that.
And I want to, part of it is I want to explain to the jury that this is more, is this time consuming to do all this DNA analysis?
Yes, it is. It takes multiple days, weeks, months.
And in going through your reports, I know that your first report was authored May 29th of 2020. Is that right?
Yes.
And that your last report was authored July 19th of 2022.
Yes.
And you've been working on, so I mean, I want to give the jury an idea that this is not something that is done in 20 minutes or even a day, that this takes weeks, months, years for all the DNA testing that you're doing.
That's correct.
That's all the questions I have, Your
All right, may this witness be excused? All right, thank you, Ms. Heistler, you're excused. All right, are we wanting to call one last witness?
We have one last witness we can call. It should be relatively brief, albeit we have to go through some photographs.
All right, ladies and gentlemen, just for scheduling purposes, this will be our last witness of the day. Is everyone okay to hang tight here? Do y'all need a bathroom break? You want to go forward? Everyone's good? Okay, I see hands going like this. All right, very good. Then State, call your next witness.
Call Dr. Robert Pitek.
Yes, sir. Thank you. I don't want to publish until he's ready to go.
Okay. I'll do it after. All right, Dr. Pitek, if you'll come forward and be sworn. All right, sir, if you'll just be sure to speak closely and clearly into that microphone.
Doctor, go ahead and introduce yourself to both juries, please.
Good afternoon. My name is Dr. Robert Pitek.
What do you do for a living, sir?
I am a chief medical examiner.
What's that?
That's a role that I play in the District 4 medical examiner's office as the chief, overseeing the operations of the office as well as supervising the other pathologists.
So how long have you been the chief medical officer or doctor in the Fourth Circuit?
6 years.
How long have you been a medical examiner?
Since 1999.
Explain to the jury your education, training, experience that allows you to operate in that capacity.
Yeah, so after medical school, I attended a residency program in both anatomic and clinical pathology at the University of Kansas Medical Center. This was followed by a senior residency position at the Hahnemann University Hospital in Philadelphia, which was followed by a fellowship program at the Philadelphia Medical Examiner's Office in the branch of forensic pathology.
What's pathology?
Pathology in general is the examination of tissues and bodily fluids to determine a disease state within the body.
So we've heard things like send a sample, like a skin, potential skin cancer to the pathologist. Is that what you're talking about with pathology?
Correct. A surgeon will remove a piece of tissue that gets sent down to the pathology, and the pathologist looks under the microscope and determines the disease process.
What is a forensic pathologist?
So a forensic pathologist is a subspecialty of general pathology. This has to do primarily with the determination of the cause and manner of death.
And do you have specific training in that regard?
Yes,
Are you board certified as a forensic pathologist?
I am.
Are you a medical doctor?
Yes,
And you're licensed to practice medicine here in Florida?
yes.
Approximately how many times have you testified as a board-certified forensic pathologist?
It's been hundreds.
Have you been allowed to give your opinions on cause and manner of death?
Yes.
Your Honor, at this time I would tenure the witness as an expert in this field.
All right, any additional voir dire from Defendant Whitaker? And from Defendant Robinson? All right, thank you. You may proceed.
Thank you, Your Honor. So we mentioned cause and manner of death. Can you explain to the jury what a cause of death and then what a manner is?
So a cause of death is any process or injury to the body that causes the heart and brain function to stop. Manner of death, from the standpoint of a medical examiner, can be divided into 5 separate categories. It can either be natural, accident, suicide, or undetermined.
And is it your job to determine how somebody died and then how that death came to be?
Yes.
The uses of autopsies, explain to the jury why that is necessary for you to determine cause and manner of death in most cases.
In most cases, the individual comes into the office. There may or may not be a history. We have to do the examination, both an external and internal, to determine what's actually going on disease-wise or injury-wise.
And is photography important for that?
Yes.
And why is that?
Each case gets photographically determined and qualified and put in the autopsy report.
So, sometimes we think about medical records. Have you written a medical record report in this case?
I have written a postmortem report.
Okay. And so that's akin to a medical record, but you have hundreds of photographs that you're also able to refer to. Is it important to go back and refer to those photographs because 5 years later you may not remember everything?
That's correct.
Okay. And have you reviewed the photographs in this case as well?
I have.
So do you have your file with you, doctor?
I do.
And is it going to be in ME medical examiner number 2137?
20-0137, correct.
And the name of the deceased was the Charles Quentin McCormick Jr.?
Correct.
And is that who you performed your autopsy on and rendered opinions about cause and manner of death?
Yes.
Your Honor, at this time the parties have entered a stipulation.
All right, ladies and gentlemen, when the parties agree that certain facts are true, that's called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is that the body examined by medical examiner Dr. B. Robert Pitek on January 31, 2020, marked as ME number 20-00137, was the body of Charles McCormick Jr.
Thank you. And Your Honor, I think we have a Scrivener's error as to the date. Doctor, when was the date of your autopsy that you did in this case?
It was on January the 16th, 2020.
Okay, we're going to go through a series of photos, but just to begin with, I think it's obvious. Doctor, have you subsequently watched a videotape purported to be the shooting of Charles McCormick?
I have.
Okay. Regardless, were you able to determine what killed Mr. McCormick?
Yes.
And what was that?
Multiple gunshot wounds.
And was the manner of death a homicide?
Yes.
Okay, we'll wrap that up at the end. Now I want to go through the photographs. If you can explain to the jury these series of photographs and what they mean. And your screen, if you need to telestrate anything, you can use as a telestrator. We're first going to look at State's Exhibit 148. What's the purpose of this photograph?
This is the identification photo of the decedent.
And that is the unique medical examiner number of 2137?
Correct.
And do we know the injury to the left cheek of the individual?
Yes.
Now we're looking at State's Exhibit 149. What is this?
The front view of the decedent, still with the clothing on.
And is there a measuring stick there?
Yes.
And what is the purpose of that?
to get an approximately measurement of the height of the body.
And referring to your report, were you able to get a height and weight of Mr. McCormick?
Yes.
What was that?
The height was measured at 70 inches, the weight 143 pounds.
And 70 inches comports to 5 feet, 10 inches?
Correct.
And why is it important to show the body clothed, and then later we'll see photographs of the body unclothed?
Generally, in the entire scheme of things, when the body comes into the office, we get an as-is photograph. Then the clothing is taken off, and we get further photographs.
State's Exhibit 150, is this a photograph of the collection of that clothing?
Yes, it is.
State's Exhibit 151, is this Mr. McCormick after the clothing was taken off?
Yes, it is.
Do we note significant injury to his head and face?
Yes.
State's Exhibit 152, is that chin injury that we previously saw in the identification photo?
Correct. This is an entrance gunshot wound to the left cheek.
And how can you tell it's an entrance versus an exit?
So an entrance usually has a small abrasion margin surrounding the edges.
And so you can tell from your training experience and education that this is an entrance wound.
Correct.
And you can say that within a reasonable degree of medical certainty.
That's correct.
State's Exhibit 153, what are we looking at here?
This is the corresponding exit wound to that previous entrance wound.
And you can tell that based on your education, training, and experience.
Correct.
So the measurement things here, is that just to document the size of the wounds?
That's correct.
State's Exhibit 154, what are we looking at here? We're not going to dwell on this one, but what are we looking at?
This is an exit wound to the top right portion of the head.
So the nature of that significant wound, doctor, does that give you an opinion about the type of ammunition that was used to shoot, or the type of rifle or firearm that was used to shoot Mr. McCormick?
Yes, when I take a look at the entrance wound.
We're going to see that in a little bit, but go ahead.
Yes, and compare it to the exit wound. Certain types of ammunition produce characteristic wounds.
And what type of ammunition do you see from these photographs?
A high-powered weapon.
State's Exhibit 155, what are we looking at here?
This is an exit wound to the left top of the shoulder.
State's Exhibit 156.
This is the corresponding entrance wound to the left armpit.
State's Exhibit 157.
A little bit further down on the left is the entrance wound to the left chest.
158.
Here's a entrance wound to the left hip.
159.
There are multiple superficial lacerations on the left lower leg.
160.
There's an entrance wound to the top of the left foot.
161.
Corresponding exit wound to that left foot.
162.
Here's an entrance and exit wound to the medial portion or the side portion of the right leg.
163.
These are exit wounds to the right hip.
164.
A superficial laceration to the right arm.
165.
I believe this is a close-up view of an entrance wound to the upper left thigh.
166.
Here we can see entrance and exit wounds to the back of the left heel.
So we see one of them very clearly. Is the other one beneath the 4 on the ruler,
Yes.
on the white ruler? Say Exhibit 167.
This is again the bottom portion of the left foot.
168, is that entrance wound that we saw with the massive head wound earlier?
That's correct. This is the corresponding entrance wound to the back of the head.
And so is it very common for the entrance wound to be very small and the exit wound to be significant?
Yes.
Why does that happen?
The amount of pressure that goes through the gunshot, it creates a cavity and causes more damage on the exit than on the entrance.
169, what are we looking at here?
These were teeth discovered in the body bag.
So you document, photograph those, and collect them?
Correct.
170, what are we looking at here?
So here we are looking at an x-ray of the chest and the right arm and a portion of the left arm. Here we see a bright white metallic object.
If you could circle that, doctor, so we can see what you're talking about. Thank you.
Which corresponds to a bullet.
And you were able to remove and collect that bullet?
Yes.
State's Exhibit 171, what are we looking at here?
Here are other fragments in the right arm and just right of the right chest.
Circle those so the jury can see. Thank you. Next. 172.
Here we see another bullet fragment on the left lower abdomen.
Thank you. And then 173.
Here we see multiple fragments, or actual bullet fragments, in the right leg and portions in the left leg.
Thank you, doctor. 174, is that a collection of some of those items?
That's correct. These are the evidence envelopes that I created, documenting where each fragment was recovered from.
175, again, some of those items that were collected?
That's correct.
These are going to be fragments found within the body?
Yes.
Exhibit 176, can you specifically talk about what I consider a relatively pristine bullet here? Is that the one we saw in the chest, below the clavicle, I guess?
That's correct.
I'll show you that in a second. I'll show it to you now. All right, we have one of them, doctor, the very, what I consider pristine bullet. It was taken in the cavity, the state's exhibit 12. Is that going to correspond to the, to 170?
That's correct. That's the bullet recovered from the mid-chest.
And there are notations and documentations on the envelope to show it came from your office, meaning you collected during the audit.
Yes.
Your office is trained about how to preserve and collect evidence.
Yes.
And then I'm going to show you three other items that were collected. I don't think these are the evidence, but I'm going to show you what's been pre-marked. The state's exhibit 9F. 9G. And 9E. Do these three items, take your time to look at them, come from your office and were collected during the course of your autopsy?
Yes, they were.
Now, I would move these three items into evidence as their pre-marked numbers.
Okay, is there any objection from Defendant Whitaker? Any objection from Defendant Robinson?
No, Your Honor.
All right, then State's Exhibit 9E will be moved into evidence as State's Exhibit number 213. State's Exhibit 9F will be moved into evidence as State's Exhibit number 214. And State's 9G will be moved into evidence as State's Exhibit number 215.
Thank you, Your Honor. Doctor, approximately how many gunshot wounds did Mr. McCormick suffer from?
Total of 9 gunshot wounds.
And were all of them lethal?
Well, any gunshot wound can be lethal. We usually, when we talk about gunshot wounds, which are more serious than others. And in this particular case, the more serious ones were to the head and to the chest cavity.
So, like, for example, the one that goes through his foot may kill him, but it's unlikely.
Correct.
And the one that went through his head would have been much more serious, and the one that went through his chest would have been much more serious.
Yes.
The 9 gunshot wounds, was there any other explanation in your examination as to what ended Mr. McCormick's life?
No.
And so, within a reasonable degree of medical uncertainty, what was the cause of his death?
Cause of death was multiple gunshot wounds.
And what was the manner of death?
Manner of death was homicide.
Thank you. Doctor, I appreciate it. I have no further questions.
All right, cross-exam from Defendant Whitaker. Cross-exam from Defendant Robinson.
Yes, Your Honor, briefly.
Okay.
Doctor, good afternoon. My only line of questioning is with respect to height. Now, when you measure height of somebody that comes to you, they're laying down, correct?
Correct.
And as a doctor, that could be different than standing height, correct?
It may be, yes.
By small margin.
Correct.
And the reason for that is things like loss of muscle tone.
Correct. There may be some rigor mortis more pronounced than usual.
Also, when you're measuring, now you came back at 70 inches. That's an approximation. That's why we have a round number instead of 70.3.
Correct.
And then finally, post-mortem, can there also be changes in the body that affect height?
Like I said, there may be some advanced rigor mortis, or there may be complete loss of rigor mortis.
In general, the changes, it could be somebody is a little bit smaller than they were when they were living and standing.
Usually it's just an approximation, so it's not a real definite measurement.
He could have been standing before he was killed. He could have been 5'9".
It's possible, I don't know.
Could have been 5'11". You don't know.
Sure.
But there's a range, and yours is just an approximation, not an accurate living height assessment.
Right, based on the body lying on the tray and the measuring device, yes.
Thank you so much, doctor. That's all I have.
All right, is there any redirect?
No, Your Honor.
All right, may this witness be excused? Okay, thank you, Dr. Pitek. You're excused and free to go. All right, ladies and gentlemen, it is 5:30 on the nose. We are going to recess for the day. I'm going to ask that you leave your notepads on your seats. We will lock them, secure them, and return them to you when we reconvene tomorrow. Again, we'll be here in courtroom 407 starting at 9 o'clock, where we will continue with the state's case in chief. I must remind you that during this overnight recess, you're not to talk about this case among yourselves or with anyone else, or allow anyone to say anything to you or in your presence about the case. And of course, again, if anyone attempts to speak to you, please notify me by giving a note to the bailiff. Additionally, please make every effort again that overnight tonight and tomorrow morning you do not read, watch, or listen to any newspaper stories or television shows that might be aired about this case. And that's because this case has to be tried by each of you only on the evidence presented in this courtroom, in your collective presence, the presence of the defendants, the attorneys, and this court, and only based on the facts and evidence that come out at trial and on the law as I instruct you in it. So please make every effort to follow those directions. And I'll just remind you again, if you do see witnesses or attorneys outside as you leave today or tomorrow morning as you return, you are not to engage them in any conversation whatsoever. So with that, I wish you a good evening, and you are now excused and free to go.